additional affidavit on item number 22 to 24, my lord.
Matter pertains to non-issuance of PDS license, Lordship. Previously, Lordship, instruction was sought for.
Lordship, there are three same matters, same subject matters, and same respondents. So this matter may be taken with that three matters.
When are they listed?
In WMC.
When are they listed? Are they fixed on any date?
No,
Lordship.
not on fixed.
What do you say?
Yes, Lordship.
Okay. It is submitted to the bar that there are other two similar matters, and prayer is made that all three matters be listed together. Accordingly, let this matter be listed along with WPC number
6720 of 2021,
6720 of 2021,
6718 of 21,
and WPC 6718 of 2021,
and 6516 of 21.
and 6516
6 of 20.
2021. So three matters. All these four matters will be listed together on a date to be fixed by the registry after the ensuing summer.
Always.
That is it. Lord, non-compliance of order dated, my lord. Relevant part of order, my lord, page 12, my lord. Last paragraph.
Mr. AHMR. AHMR, so you notice. 4 weeks. Steps on respondents by usual force and registered post 80 within 1 week.
Yes, sir.
Within 2 weeks. Yes.
Make use of my lord. In this case, government is
Yes,
supposed
Instruction is awaited, my lord, not.
What is your prayer?
My lord, my prayer is that, my lordship, I filed representation before the deputy commissioner, lordship, regarding the inclusion of my name, page 24, lordship, which was forwarded to the circle officer, lordship. But nothing has been done till date, lordship, regarding inclusion of my name for compensation, lordship. May I pray at this stage? I pray, lordship, let them notice may be issued, lordship, and in the meantime, my representation may be.
Third level council. Issued.
2, 3, and 4.
2, 3, and 4, MSP Hazarika for number 1. Learned council, since learned council represent the paper, extra copies be printed within a period of 1 week from the list accordingly after the returnable date.
May I pray, lordship, the
Pendency of the writ petition shall not be a bar to dispose of.
consider my
To consider the prayer of the writ petitioner by the circle officer.
lordship. Page 24, lordship, is the letter issued by the deputy commissioner.
Yes. In
Much obliged. I'll serve the copy, lordship, within 2 days.
1 week we have given you.
Lordship, sir.
Yes, please.
No, please. Lord, I have a very limited prayer. Lord, I have lodged a complaint with some serious allegation against some police officers. On 20,
File an FIR. Why don't you file an FIR? What has the report got to do with it? It will require investigation.
Yes, Lord.
No
Against the police
investigation
officers.
unless you set the criminal law into motion.
All right, my lord. The matter may be closed with liberty to approach the appropriate person.
Learned counsel for the petitioner submits that he be granted liberty to approach the appropriate authority and file the necessary complaints / FIR as may be permitted under law. Prayer made is not objected to by the respondent. Accordingly, the respected petition is disposed of, granting liberty to the petitioner to file necessary complete slash fire.
Available.
Petition is moved down to the.
नहीं यहाँ पे नहीं दिखी है
Yes,
मैं अपनी जगह से
revenue, who's for the revenue?
My lord, instruction awaited, my lord. An extra copy. One line.
What is the matter here? Third letter council for the party. Is for me. Next. Appears for 3 and 4.
My lord.
Yeah, I am
3,
okay.
4, 5, 6.
4,
3, 4,
5,
5,
and
6.
6.
3, I am very good.
3 you are very.
Easy.
4, 5, 6.
4,
MS
5.
M Broken for 3 and MS D Hazarika for 1 and 2. Matter be listed after the return of the extra copies be furnished to the petitioner,
हेलो
sorry, to the respondent council within a period of 2 weeks from now.
हेलो सिमिलर ऑर्डर में पास इन आइटम नंबर 11
Against which an opportunity to file his response was granted. So he further submits that against this order, the appellate, he approached the appellate authority and the appellate authority by the impugned order dated 4th of March 2024 passed this order whereby the amount of interest was reduced to 446, 434, 438, 430. So being agreed, he has approached this court as it is submitted that the GST tribunal, which is mandated under the statute, is not yet constituted. By it is submitted that when the mandate of the section prescribes imposition of taxation, then the authorities are duty bound to follow the mandate of the section and will not attempt to recover any amount which is not any amount in a manner not prescribed or authorized under the Act. Mr. B. Gogoil and Planning Council appearing for all the response. Like instructions of matter, he submits that as on date, the GST tribunal is not available. Accordingly, let notice be issued return of 4 weeks. Going in those appearances on behalf of all the respondents, because the way our extra copies be furnished within a period of 2 weeks from today. Matter be listed after the return of the date. Meanwhile, the recovery is in it. Your only grievance with regard to interest. In respect of the interest as reflected in the impugned appellate order dated shall not be proceeded with till the next date fixed. Matter be listed on 5th of August. Deeply okay.
Lordship, Senior Counsel Mr. N.K. Chaudhary is on late. So, madam, we part of the time.
This is only for notice. What else is it? There is no interim order.
My lord.
Is there an interim prayer?
My lord, I'm not sure about that.
May I please, Lordship? Actually, here the thing is that the accused got a phone call from the police station on 10/6. Right now, till right now, the FIR has not been registered. He just received the call and no FIR has been registered. The thing is that on the accused has filed one FIR against the respondent on 1st of June at Narangi PS station. He was the general manager of the hotel which is owned by SMN number 5. Now coming to the basic point is that on 10th, this respondent number 5 has filed one FIR at there. So the police is calling him, but neither it is registering it. So if it is not registered till now, we are not able to file the bill, this one also. But he constantly calling, you come down with all the documents. No 41A has also been given to us. So he apprehends that because we have waited till 21st. The 21st we have moved this thing actually. So we apprehended in the coming days, it might get registered because the High Court will be this one closed actually. So we
Is
apprehended.
bail to be granted only by the High Court?
No, district court also, but
Then-
we just apprehend that thing because
So-
this type of matter
That's
has
the question of apprehension that they may not be able to approach the High Court.
no.
because
We
of
can
summer vacation.
approach that court also, but we are apprehending that so, because the last 18 days actually he is just calling, but he has not.
Yes,
registered
and
it.
Eric,
And, one thing, if I may most humbly draw your lordship's attention to page 11 of your lordship's brief, but a writ in the nature of mandamus directing the Dispur police station to properly follow the procedure.
This is what we want actually. If the FIR is
The
been
code,
registered,
the CRPC, my lord, whether it permits.
so just get an instruction, what is the issue about? That's all. You're not issuing notice at this stage.
Yes, my lord.
Just obtain your instructions. What is this? What are the, if there's anything.
Is there any
registered
basis
against
for
him,
his
If
grievance?
any FIR is registered against him, just find out from the police station. Learned government advocate will obtain instruction matter. Let the matter be listed immediately on reopening.
Well, if I may be
IS Mazumdar appears for the petitioner. Extra copies
deeply.
will be served during the course of the day, enabling the respondent counsel to obtain the required instruction. This on 15th of July.
I will.
my lord,
15 July.
Extra copy.
My lord, this is a petition by the wholesaler. Yesterday, we moved the petition for the retailer. It can come on the reopening, but the other matter is 17, my lord. And same, my lord, that coercive measure may not be taken.
But this is wholesaler.
Same position, my lord, even wholesaler deal in duty paid goods, duty paid liquor. Because the moment it leaves the, my lord, manufacturing premises, the duty is paid. Same principle, my lord. In fact, we have stated in this paragraph. If your lordship would kindly come to para 16, where we have detail everything. Para 15, my lord.
Yes.
That under the scheme of the Act of 2000 and the rules framed thereunder, how the statutory provisions operate has
You are agreed by the
same demand notices, my lord,
retrospective imposition.
and demand notices. Same position like retailer.
Yes.
Again, that same issue will arise at what price they have allowed the retailers to lift the stocks from
They
their.
will see.
Yes, Lord, same.
If ultimately, if they're required to pay, they'll pay.
Yeah,
It will not be accepted that they did not sell it at that price, and therefore they cannot pay.
Okay.
Heard Mr. K. N. Chaudhary, learner senior counsel, assisted by Mr. Adam Dekha. Mr. K. P. Pathak appearing for all the
Numbers 1 to 6, your lord.
1 to 6.
7.
Mr. P. Gogoi for respondent number 7. And issue notice returnable on the same deadline. Till the next returnable date, no coercive action
Oh,
taken in terms
Right.
in respect of the. This is again an association,
yes, my lord. This is the wholesaler association.
respect of the wholesaler petitioner association. In terms of the demand notices issued to the individual. the association.
Lord, it may be tagged with along with 3280 of 24.
It will be listed along with UPC 3280 of 2020.
Lord.
The extra copies be furnished within a period of 2 weeks.
Yeah.
Yes,
May it please the Lordship, this is a petition challenging the order dated 9/2/2024, passed by the Department of Agriculture, Lordship, wherein our representation for holding election to the Agriculture Market Committee has not been addressed at all, Lordship. The only thing that they talked about was whether they wanted to extend the term of the committee or not. But our main,
which order you are challenging?
Lordship, it is in page 26, Lordship. And Lordship, our representation is in 24, page 24, Lordship.
So when are the elections or what is the provision?
Lordship, the provision is under section 9A.
All I will issue notice at this stage, heard, done it, counsel to the petitioner.
Lordship may consider my interim prayer, Lordship.
Mr. History appears for
Yes, I am for responder 1 and 2, Lordship.
1 and 2. Mr. Gugoi for 3,
3 and 4.
3 and 4. MS Borman for 5. And who appears for 6? Why 6 is the party? Why 6 is the party? Warehouse
They are a member of the
committee.
Otherwise,
Petitioner
petitioner
is
has no
aggrieved
locus standi to file this.
by the impugned order dated 9 February 2024, whereby the petitioner's application dated 18/11/2024 and 5/1/2023 was rejected. He was directed to hand over was rejected, and it was held that its application for extension of term of the Guwahati Subdivision Market Committee, his application for extension of his term as a chairman of Guwahati Subdivision Market Committee has become infructuous. Why is it become infructuous?
Because already the ad hoc chairman has been appointed by the government, Lordship.
By which order?
This annexer E, Lordship, page 26, Lordship.
that order was in violation of interim orders of this honorable court, Lordship.
28, page 20. Page 28. Page 28.
No,
Yes,
it he commits that the government by order dated 2nd of March 2022 has appointed the district agricultural officer Cooperative Metro to take over charge the Guwahati Subdivision Market Committee as the chairman with immediate effect. You are not challenging
No,
this.
he has not challenged this order.
Lordship,
28.
that order will have to be treated void because, Lordship, I have 2 interim orders that was passed in the earlier round. And this order was passed in between, Lordship.
No,
when
what happened?
status-
What happened to those writ petitions?
that writ petition was disposed of by your Lordship.
How does this interim order matter when the writ petition is closed?
Because, Lordship, that interim order was talking about maintaining status quo, Lordship.
Whatever it may
Now, when the
be, writ petition was disposed of.
dispose of the interim order goes.
But this order was passed in between when they were supposed.
Mr. Council, your writ petition on basis of which these orders were passed have been disposed of. There is no direction that these interim orders have been made absolute.
No, Lord.
No, Lordship.
How does it matter?
And
Today,
But that order, Lordship, does not have a legal standing. Because
you make legal arguments.
Lordship, after opening the discuss quota, they not appeared for 2 occasions, so it was disposed of.
And in the impugn order lawsuit, it is categorically said that the petitioner has no right as well as locus standi to claim himself as a chairman of so-and-so committee lawsuit.
Yes, yes.
That is there.
Learned counsels for the respondent submit that in view of the order dated 2nd of March 2022, whereby the subsidiary market committee chairman charge was handed over to the district chairman, more particularly as its term, as the term of the committee, including the extended term of the committee, expired. So, let notice be issued, returnable be listed after the returnable date, notice on the interim prayer, returnable on the same day. It's accordingly. Listed on
It will come.
9th of August.
Yes.
9th of August.
9th of,
Lord, can it be closer, end of July?
end of, we'll have it on 2nd of August.
Yes, yes, your lord. Extra copies may kindly.
Extra copies be furnished to the respondent.
Oblige you.
My lord, as per mandate of Article 243I, my lord, funds, Finance Commission funds are distributed to the Gaon Panchayat, my lord. Accordingly, what happened in 2 Gaon Panchayat, erroneously, my lord, what happened? In one Gaon Panchayat, my lord, higher population is there, their population was transferred to another Gaon Panchayat. Accordingly, a repetition was preferred by the Vice President, that GP, my lord, page 29, the order, my lord. Paragraph 7, page 29. To redone the process, my lord. Page 29, and except 2. Paragraph 7. After hearing the parties and taking into consideration the facts and circumstances, including the material in the parawise comments issued by the Chief Executive Officer so-and-so, this court is of the opinion that the exercise for allotment of funds under so-and-so Finance Commission of the Gaon Panchayat in question is required to be redone, since the assessment of the population has already brought on records by means of written instruction as indicated above, the respondent number 1 commissioner so-and-so to redo the entire exercise to evaluate the correct allotment of funds is required to be allotted to the Gaon Panchayat. This is the order, my lord. Thereafter, my lord, a cabinet decision was taken, page 32. And then, my lord, everything will clear by annexure 5, page 33, my lord.
Yes.
Page 33, my lord. This
Yes.
is the, regarding revised population figure of Charagi GP to Chorgula GP. With reference to the subject cited above, I would like to inform you that the request for rectification of the population figures of Charagi and Chorgula Gaon Panchayat under Karimganj as part census 2011, which was erroneously reported in Assam Finance Commission, has been approved by the Honorable Cabinet in the meeting dated so-and-so. Thus, now population of figure of Charagi, we are concerned with my lord Chorgula. Next, and Chorgula is so-and-so as per so-and-so. You are aware that 15 finance grants are transferred to the GPs based on the population. All the previous transfers of so-and-so period, so-and-so, FC grants to Chorgula was based on population of so-and-so.
So what is your grievance?
My grievance is that, my lord, pursuant to that, my lord, the excess fund which was transferred to my lord Chorgula Gaon Panchayat was sent to the original Gaon Panchayat. And then, my lord, as per section 126 of the, my lord, Assam Panchayat Act, the Anchalik Gaon Panchayat shall prepare the, my lord, action plan and submit it to the, my lord, Jila Parishad Gaon Sabha.
And how are you aggrieved? Why are you?
I am aggrieved because, my lord, now, my lord, the authority, the district commissioner, the act which step has to be done by the, my lord, under the Panchayat Act, my lord, by the Gaon Panchayat is now doing by the, my lord, deputy commissioner, my lord. Since action plan is there, my lord.
You are a what? You are an.
I am the resident of that Gaon Panchayat and ex-president of the Gaon Panchayat.
You are president of which Gaon Panchayat?
Chorgula Gaon Panchayat. And, my lord, action plan was submitted in, my lord, from page 38 onward.
Okay. Well, let us issue notice here. Yes, what do you say?
Main preference is against deputy commissioner, my lord. Notice may go, my lord.
And, my lord, till then, my lord, not to modify this scheme, my lord. This is an approved scheme. by the my lord, pro Gausso Baba.
Is returnable on after 4 weeks. Mr. has also appeared for
1, 2, 4, 5, and 6.
1, 2, 4, 5, and 6.
Yeah.
MS M. Borman appears for respondent number 3. Should notice on the interim prayer returnable on the same date. It's 6th of August. The respondents may complete their instructions and file necessary affidavit. The petitioner shall serve extra copies of the next petition within a period of 2 weeks from today. We have issued notice, we'll consider your prayer on the
My lord, so
returnable
far
date.
as the my lord, no modification till then, my lord.
Why?
If my lord,
Who is
modification,
to modify?
Deputy Commissioner, I have specifically alleged, my lord.
So,
I have specifically alleged. My lord, in page 21.
we'll see on the returnable date.
My lord,
Let them get their instruction.
Allegations are against the MLA also, my lord,
my
but
lord,
not
MLA,
party.
my lord, at the instance of MLA, he is modified.
What happens if it is modified?
Modified, my lord, the scheme will be diverted, my lord, under the Panchayat Act, 126, lordship kindly
We'll
say.
set it right on the returnable date if required.
But in the meantime, if anything happen, my lord,
If anything happens, it will happen. We'll see what can be done. Why should we uh, interfere with what the deputy commissioner is?
my lord, what Deputy Commissioner has no rule to do. Under the Panchayat Act, it is the Gaushoba to make, prepare the plan, my lord. Lordship kindly see.
That's all right.
My lord, thing is that-
You will hear the matter on the next day,
My lord,
depending on what.
some personal interest is also there, my lord, because he was
This
the,
is also my
Whatever
prayer.
you get your instruction.
my lord.
My lord, this is also my prayer that let them execute the work through their agencies, my lord. I have nothing to do with them, but
We'll
only
hear-
thing is that
We'll consider your returnable, your interim
Obliged.
prayer on the returnable.
I live now.
that may be my lord indicated.
The interim prayer to be considered on the returnable. Yes.
But only anxiety is may not will amount to changing the character of the land, provided some part of it falls in my statement. Well, at least some protection, my lord. At
What
least
protection?
till PWD comes up with an answer whether they are encroaching or not, and whether the circle officer gives a report from the demarcation exercise, which I have been pursuing from the last 2 or more years now.
Who are you?
And I'm the estate
You are aggrieved by what?
non-exercise of the demarcation process. My
Where?
lord, I have been approaching the circle officer repeatedly seeking
No,
demarcation of my
demarcation
land.
for what purpose?
My lord, I'm sorry,
Demarcation for what purpose?
to demarcate my property, my lord.
Is it not already demarcated?
No, my lord.
Why?
My lord, what happened is at one point in time, the owners were killed in another estate in Tinsukia. Then everything fell down, my lord, and I being the son of the erstwhile owner, my lord, I was able to revive that entire estate. Now we do not know which is our land actually. And from either in the eastern side, there will be.
How have you revived it?
Well, from the papers also, it is quite clear that some people have encroached and removed the fencings also. And it is not possible to give a boundary wall in the entire estate, my lord. It's a very huge property. At least till the returnable date, my lord.
Where is your application?
My lord, in fact, all of the, my first application was in 3/6/2019,
So page number?
28, my lord.
28.
28. And from 2019 onwards, I have been following. I mean, in fact, all of the annexures are my applications before the circle of the order. And the government.
Yes, respondents, anything to some?
It's a remedy under the Assam Public Services. Right to public service.
Yes. What remedy?
appeal and review and all that.
You can, if it is not acted upon, you can seek recourse to the provisions of the act.
You find out whether it was acted upon, not acted upon. It is why the circle officer is not acted upon. If at all. Right now, get the instruction. Heard, the council. The writ petition filed by the petitioner aggrieved by the non-consideration of the application before the concerned circle officer, namely, what is that circle officer? Polakbari.
Polasbari, my lord.
Circle officer Polakbari in not demarcating the boundary of the petitioner each state. So the petitioner has been consistently filing applications before the authority, seeking proper demarcation of the boundaries of the tea garden. However, no response was forthcoming from the circle officer. Consequently, the petitioner is before this court. Para issue notice Mr. MSP Hazorika for respondent number 1. Mr. B. Gogoi for respondent 2. Why is PWD a part?
Because at one point, at one part, my lord, they claim that they are contractors of the PWD and have started some construction of some stadium or
S. Sharma,
2 and 4.
Mr. B. Gogoi for 2 and
2 and
4.
4.
MS S. Sharma for 3, 5, and 6. Let the respondent, more particularly the respondent number 5, apprise the court or if any steps have been taken towards the demarcation of the tea garden as prayed for by the petitioner. Matter being listed immediately after reopening, date to be fixed by the registrar.
status quo till then, my lord, to fix a,
Status quo for what?
my lord, over the land filling exercise, I have annexed the last page, my lord, to see, my lord, they have started filling land with JCBs and on and.
Go and file a suit.
My lord,
You go and file
this
a
is
suit.
against the executive, my lord. I have been approaching them and they themselves write to the circle officer for seeking demarcation, my lord.
Not
That is
like
also
this.
there, my lord.
Not like this, Mr. Counsel. What are you?
My lord,
asking
injunction
for?
is something else, my lord.
What interim orders, blanket interim orders, without any finding as to what is your land, what is their land? How? On what basis? You know the remedies available to you. Go and approach them. Mr. Chaudhary, we are not inclined to pass an interim order as on date. We can keep it open for the returnable date. Issue notice on the interim prayer, returnable on the same. Then we'll have to fix a date.
Your worship, we can get it.
29th July. 29th July.
You can have the list.
Please, your lordship, this is cancellation of GST registration.
Yes, any
The
instruction.
recommendation of.
They were supposed to place some recommendation of the GST. That was
GST.
one of the council.
Show it to him.
That the lordship has already considered, madam. Probably that will not cover this case.
Lordship, only I was pointing out this, so that because lordship, that
So they are referring to coordinate bench's orders.
Yes, madam.
Just have a look and tell us if it is.
given WhatsApp copy also of
Pass
the
this order, we'll close it.
Amish Basumati.
My lord, Amish Basumati, to my lord, submission, my lord, what I found, my lord,
There's
this is
another
not
order.
covered, my lord.
There's another order.
My lord, so far Amish Basumati is concerned, it is not covered, because my lord, that matter pertains to my lord central excise. There is a special provision, my lord. In fact, the honorable Supreme Court has recorded it in that my lord report as well. Lordship will find in the page 5, from the bottom, my lord, reported in 2017-11 as CC 730. There was amendment and the honorable High Court has been given the power to, my lord, condone the delay. But in the present case, my lord, relating to GST, there is no such provision. I have the judgment, I can place it, my lord. Categorically. That's why honorable court said that the High Court should have, and my lord, the delay was only 14 days. Here it is of 2021. They preferred the appeal in 2024.
No, you go through the other order.
My lord, only one has been given.
They don't need your copy.
I will have to check, my lord. I can't say because it has not been given, details are not given, my lord. Only one para in para 5 it says, my lord. Maybe there are ground in that particular case, my lord. Lordship will post it after vacation, my lord. I will.
Lordship, I have got hundreds of cases in which Lordship there is no objection from the state, Lordship. There are not even, this is not the first case. This
Bring
is-
those orders.
Lordship, all the orders are there with me. So if there is not even single objection and Lordship, because what will happen, Lordship, if my cancellation registration is cancelled, how will I proceed with my business, Lordship? I don't
You
think so,
can
Lordship.
apply afresh. That is my instruction.
Lordship,
But I
I am
cannot go
ready to-
beyond my
once-
written instruction from my
once-
client.
Benefit, you can't take it away.
Say, Lordship.
That Lordship will
Then the
decide, my lord.
goodwill is there.
It is in the motion stage. Lordship will issue
Why
notice, my
goodwill?
lord. Lordship will decide, my lord, in one, at least one case. my lord.
All right. Third learned counsel for the party. It's the appeal for the
All respondent.
all the response. Once of the petitioner think that the GST registration was cancelled because of non-deposit of taxes.
Lordship, not
Is the
not filing of returns.
Return in
Last 3
filing of
months.
return.
SOCO's notice was
File an
covered
appeal.
served on me.
Did you file an appeal?
Yes, Your Lordship. That was also rejected.
Where is page number?
Lordship, my GST appeal is 53 and the impugned rejection order is at 60. 60.
Against the cancellation order, an appeal was preferred because the authority, which, however, came to be rejected.
25 April 2024.
Page number 60.
60. 0.
On the ground that the appeal was filed beyond the limitation period prescribed. Accordingly, same was rejected, being agreed, present writ petition has been filed. Issue notice returnable
Lordship, a fixed date may kindly be given.
on
24th. Lordship. 18th of July, Lordship.
we'll have it on 29th,
29th.
29th of July. Notice on the, you have any interim prayer?
No, Lordship, there is no interruption.
Respondents may file their, complete their instructions and file necessary amendments.
Matter. All right.
Lordship, an endeavor can be made for the dispose of the matter on the.
Sorry,
An endeavor can be made. to
what is the meaning of giving that observation? We'll dispose it of.
Yes, sir.
May I please, your lord? Lord, on the last occasion, my lord, my senior friend was about to produce some records, my lord, regarding that procedure they have adopted for the following the PPE Act. my lord.
Yes.
Worship, in fact, I have the records. And it appears that the petitioners were not there when the proceedings were taken up,
Not there means?
not in that plot of land.
Uh.
When these proceedings were taken up, they have come thereafter. Because I apprised your lordship,
You bring it on record. We'll give you 2 weeks,
Worship, that is all.
immediately after vacation.
I can bring it on.
Can you
record.
bring it on record?
Yes, voluminous,
No, your stand
Yes.
that these people were not available
were
and
not,
there are
because
records available to show.
what I had apprised your lordship on the last occasion was 158 families were there. And now a petition is filed,
If
158,
that is found to be correct, then we are passing strictures. We are putting you to notice.
in this 158 lordship, they are not there.
Heard, Mr. T.R. Miyalar, Mr. R.K. Dev Chaudhary, learned DSGI, appearing to be Indian Railways, and Mr. H. Sharma, additional senior.
5 to 8.
Correspondent 5 to 8.
Next question.
The learned DSGI submits that he has the records of the proceedings undertaken under the PPE Act in 71 with respect of eviction of the land eviction from the land in question belonging to the railway authority. He submits that there are, as per the records available, the present writ petitioners were not even present on the same disputed land. Rather, they shifted after the proceedings initiated under PPE Act was undertaken. So let this stand of the railways be brought on record by filing an affidavit. And along with relevant documents. Matter be listed on 15/9.
Not-
Can you file?
Let it be immediately on
19th,
opening lordship.
Can it be on, can it be on-
15/7.
Yes,
not-
nine.
can it be on 19th, my lord? I will be have some difficulty.
He has to file, let him file it.
Yes, sir. On,
Let him file on 15th, let us,
yes, sir.
15/7.
Fine.
uh,
The interim,
2024.
Lord, interim order may continue.
Interim orders will continue till 15/7.
My
Interim order
my
passed.
lord, another similar matter had been filed, my lord. It is of item 33, my lord.
33 lordship, same plot of land.
Same.
Petitioners are different. My stand is also the same.
Let item 33 be also listed along with item 15. Item
27.
27,
Fine.
list on 15.
Obliged.
Yes, yes, yes.
Lordship is directed to obtain inspection. My lord, what is the notification? Where there any further extension beyond the notification at page 47? My lord? Okay, there is only one notification. Data of annexed at page 47, my lord.
I mean, you said there was subsequent notification.
Yes, sir.
This is the same notification. 56.
56.
It's there, page number 47. By this notification, it has been extended
Up
to
to 30th of April, my lord. 30th of April.
your financial year is 18/19.
19, my lord.
Then
Order was passed on 4th of May, my lord. At page 48.
this is for issuance of order.
My lord.
It was passed under which section?
73, it is there in order itself, my lord.
Page number
48, my lord.
48,
48.
the section 7. Yes, Mr. KL,
Proceed the order passed by the state, my landed and will.
it appears to be time bird. Prima facie.
File a affidavit.
Counsel to the party issued it. For which the boy appears of number
Now, 3,
3,
no,
4, 5.
4 and 5.
Three,
4 and 5.
Huh?
4 and 5. 1, 2 and
4
3.
and 5.
Yes.
Mr. HCKL appears for 1, 2, 3.
1 to 3.
Maybe not.
This writ petition is directed against the impugned order dated 4th
1.
of May 2024, passed by the respondent number
No, 5, my lord.
5, imposing
It was
demand of
28.
tax along with interest and penalty
Including.
for the period for the financial year 2018-19. Learned counsel for the petitioner referring to the notification number 56 of 2023, dated 28th of December 2023, submits that the Department of Finance, Government of India had extended the limitation for issuance of orders under Section 73 of the Act for recovery of taxes not paid or short paid, or of input tax credit wrongly availed or utilized for the financial year 2018-19 up to 30th of April 2024. He therefore submits that the mere perusal of the order reflects that the impugned order was passed on 4th of May 2024, which is well beyond the period of limitation extended by the notification number so and so dated 28th of December 2020. Here I issue notice returnable 4 weeks. Since the learned standing counsels have entered appearance, notices are waived, extra copies be furnished within a period of 2 weeks from today. Matter be listed again on 5th of August till the next date fixed. Impugned order dated 4/5/2024 shall remain stayed.
Deeply well, my lord.
You are for one. MSK open for one.
Oblige, lord.
Mr. KL will be for 10.
20.
Wait, your lordship, my lord. Annexure 12 is the impugned order, my lord.
Annexure 12.
Page 46. Lord, I'll start from that, my lord. Page, the demand notice issued to me, my lord, in my tea garden, my lord.
Yes. Recovery of
Recovery of, my lord, 1,490
Provident Fund dues.
Provident Fund dues, my lord. My only grievance is that, my lord, your lordship kindly see this notice was, my lord, your lordship kindly see very fast line, my lord. Please take notice that certificate number so and so has been forwarded by the authorized officer, Court of Trustee. So that, my lord, it was forwarded by authorized officer to the recovery officer. So recovery officer sent it to me, my lord. So if I am not paying, my lord, it will take care of my tea garden, my lord. My only grievance is that, my lord, your lordship kindly say they have given a calculation, page 47, my lord.
Yes.
This tea garden was under me, my lord, from 2022, my lord. Prior to that, it was there is a receiver appointed, my lord, and receiver man is Zanex, my lord. They are running the garden, my lord. And during that period also, my lord, whatever, my lord, liabilities there, that is also included here. That is my first one of the grievance, my lord. Another grievance is then, my lord, I have during my period, my lord, from 22, I have taken, my lord. I have already paid, my lord, near about 50 lakhs. That is, there is no deduction in that, my lord, calculation, my lord. And another point is that, my lord, your lordship kindly see, as per the rule, my lord, as per the act, my lord, section, my lord, 15D, my lord, they have exercised the power, my lord. The authorized officer, my lord. Proceeding is under section 15, my lord.
Yes.
Section 15, my lord. Any amount dues from the employer in relation to the plantation of which any scheme, the insurance scheme applies in respect of any contribution payable to under this act and fund, and also case may be to the insurance fund, damage recoverable under section 16 amounting required under authority status 11A and subsection 14 of section 3 of the any charge payable under him to the act for that provision scheme insurance company if the amount is near a recovered amount specified in section 15 BGD. My lord, your lordship kindly see the procedure. 15B is the procedure. 15B, my lord. B1, my lord. When any amount is in area under section 15, the authorized officer may issue to the recovery officer a certificate under this signature and specifying the amount of area and the recovery and the recovery officer on receipt of this such certificate shall proceed a recovery amount specified therein from the plantation as the case may be. The employees by one or more of the mentioned here below. Attachment of the sale of the property, arrest of the employees, and another is also there, my lord. Now, my lord, your lordship kindly see when recovery officer, my lord, when authorized officer, my lord, issue a certificate to the recovery officer, my lord, recovery officer issue a notice. Before that, my lord, your lordship kindly see section 15D. Section 15D, my lord.
Yes.
When the authorized officer issue a certificate to a recovery officer under section 15B,
it shall not be open to the employer to dispute the before recovery officer the correctness of the amount or any other material in the certificate, and no objection of the certificate or any ground whatsoever shall be entitled to the recovery officer. 2. Notwithstanding issue of the certificate in recovery officer, section 15B, authorized officer shall have power to withdraw the certificate. That means authorized officer have the power to withdraw the certificate and correct any clerical or arithmetical mistake in the certificate, or may appear him to be necessary by sending intimation to the recovery officer. That means, my lord, authorized officer has that power to correction of any clerical or arithmetical mistake, my lord. But that notice has to be received by me, my lord. That implied that, my lord, I have entitled to get that notice, my lord. If any clerical or any arithmetical mistake is there, I have to hesitate, my lord. But that chance was not given to me, my lord.
So this is after issuance of the certificate.
My lord. That means, my lord, after issuance of the certificate, my lord, employer has nothing to do, my lord. Recovery, that will directly goes to the recovery officer, my lord. Before recovery, my lord. Before recovery officer, I cannot make any dispute, my lord. I can make a dispute, my lord, before the authorized officer only. But authorized officer did not give me that chance, my lord. That's why I'm before your lordship. My lord, very admittedly, my lord, your lordship, kindly, I have annexed 8, 9, and 10.
15D2 also gives you the power, to the authorized officer.
Not before the recovery officer, my lord. Now already recovery officer issued, my lord, notice.
So you must approach the authorized officer.
My lord, that chance was not given to me, my lord.
You have to go and...
No, my lord, already demand notice has been issued, my lord. Because that actually, my lord, that before going to, my lord, is implied, my lord. It's a principle of necessity is also demand, my lord. My lord, before sending to the, my lord, authorized officer.
Show us from the provision that
my lord, that is implied, my lord. Because if there is a provision for correction, my lord, by the authorized officer, then, my lord, it has to be hesitated before him, my lord. But I do not even know, my lord.
Yes.
Paragraph 16, I have clearly stated, my lord. So my submission before, they have sent a notice, my lord. If I am unable to pay in 15 days, my lord, they will take my tea garden, my lord. But whatever the amount I have, my lord, paid, my lord, that is not deducted, my lord. That is very, my lord, on plain reading of the, my lord, the statement, it is clearly, my lord, your lordship kindly see.
No, prior to the authorized officer issuing a certificate, I mean, arriving at a calculation, what is the procedure?
That is sent by the recovery officer, my lord. Sent by the recovery officer. Prior to that, my lord.
Is there any provision who's appearing for the Provident Fund Authority? What is the procedure?
Yes, your lordship, if you continue to read 15D, the procedure is clear.
So 15D,
Lordship,
you're referring to 2.
2, and then 3, and then 4, and then 15E. Lordship, notice of demand does not mean you can't go to the authorized officer. The recovery officer is a post office. The authorized officer calculates and then issues a certificate to the recovery officer who's just the man who will send it to the employer. Please pay. Under 15D, the learned senior read 15.2. You can always go back to the authorized officer because it's the authorized officer who will calculate. And Lordship may kindly take a look. Page 15E. What happens then? Notwithstanding the fact that a certificate has been issued. So it's not pre. Notwithstanding the fact that a certificate has been issued by the authorized officer to the recovery officer for recovery of any amount against any plantation or employer, the authorized officer may grant time for payment of amount, and thereupon the recovery officer shall stay the proceedings till the expiry of the time so granted. 2. When the certificate of recovery for an amount has been issued, the authorized officer shall keep the recovery officer informed of any amount paid or time granted for payment and subsequent to issue. 3 is important, your lordship. Where the order giving rise to demand of payment, which is what we've done, notice of demand, for which a certificate of recovery has been issued, has been modified in appeal is 15D2, or in any other proceedings under this law, and as consequence thereof, demand is reduced, but the order is a subject matter of further proceedings under this act, the authorized officer shall stay the recovery of such part of the amount of the certificate which pertains to the said deduction for the period for which the appeal or they are pending. So this is the procedure. You have a problem with the calculation, you can go back to the authorized officer.
Exactly, but I have to get the notice, my lord. What are the calculations?
Lordship,
Now only demand I have
Other
came to know.
point, this is an
Let them
internal
now, my lord, serve with me, my lord. I'll go there till then, my lord, I am protected.
under
Is,
the
is
act.
there a procedure of hearing prior to the authorized officer?
Lordship, no. And this is an internal document. It's the authorized officer giving the certificate of recovery. I don't have to tell them. That gets translated into the notice of demand. But the law is very clear. The notice of demand does not foreclose his rights to come and tell the authorized officer, you've got it wrong. And Lordship may kindly take a look. And Lordship, it's not just this. Lordship, the law is very in favor of payment. Lordship, according to
No,
this,
that's all right. Payment, we understand, but prima facie, he submits that he's was not even associated with the garden prior to
Lordship,
2022.
now, Lordship, let me get to that now. Let me get to that. I'm relying on page 47, which is the annexure. Lordship, he was only not in possession from January 2018 to February 2022. That is it, when the receiver was appointed. These demands, Your Lordship, and Lordship, bear in mind, these demands are demands earned by laborers. It's not my money. I'm just a custodian. These are 12% of salaries earned, which should have been deposited in me within 15 days of their earning. Look at the dues, Your Lordship. 2,000. From 2,000, there has been defaults. For 22 years, there has been defaults. No, he left at 18. So there has been defaults. And he says in his writ petition, he has said he has paid, and that you find, Your Lordship, at page 34. This 47 calculates how much he's paid. The total outstanding, Lordship may see page 34. This is of 11/2/22. The total outstanding of Provident Fund to his account. And Lordship, I keep repeating, this is amount earned by the worker and not deposited. It's a criminal offense. Within 15 days of salary, he was required to deposit with me. 86 lakhs is the outstanding. He pays 30, he pays 10, and he pays 46. Of 46, 10 lakhs bounce checked. Of the balance of which Your Lordship may find at 47, which is 8 lakhs. Lordship, they want to come, they are free to go to we don't want to charge them more than what they are liable to pay. I'm not making money out of this. It's somebody's money that should have come to me so that the workers get it back. It's not me making profit.
Yes.
Lordship, if they want to go, they still have time. 15 days of notice of demand attachment. So they still have time to go to the authorized officer.
See, there are situations. Here.
My lord.
One is that it is an absolutely wrong calculation.
Yes, my lord, that I have to hesitate, my lord. They have not given that calculation to me, my lord.
Not an absolutely wrong.
Go and approach the authorized officer.
But yes, I can, my lord. That is my pair, my lord. Let them that is certificate wishes, my lord. They are calculated that let given me, my lord. Then I'll everything, my lord, page to page, I'll explain before him, my lord. But I have to get a chance, my lord. Immediately, my lord, they have issued the notice, my lord. The certificate issued against me.
Of the provisions of the Act.
My lord, that is implied, my lord. Suppose they are going to, my lord, the calculation, whatever the calculation they have sent to the recovery officer, my lord, they will accept it, my lord. I have no right to, my lord. Behind my back, then that is done it, my lord.
You have, but unless it's provided under the specifics of the Act.
But then how can I, my lord, approach them then the recovery of the certificate officer?
Challenge, correct.
Telling you,
My lord, no one can be punished, my lord, without, my lord, giving an opportunity, my lord.
you have your officer. Take these.
No, my lord, their calculation, how they made the calculation, I am entitled to get, my lord. The certificate, what they, my lord, submission made that, my lord, certificate,
So
that the internal matter, he cannot be.
Give you liberty to approach the authority.
My lord.
Dictate and tell them that these are your calculations according to them.
No, that what stayed in the certificate, my lord, I do not know. That has not been given to me, my lord.
This is the detail, page 47.
Yes, Your Lordship, the annexure.
And my lord, your lordship kindly see at prima facie, my lord, your lordship kindly page 28, my lord. Now, my lord, the period of my lord, when my lord, Genix, my lord, receiver was that, my lord, that liability, cannot be labeled to me, my lord.
You go and agitate before the authorities.
Because that is in the earlier agreement, that is clearly
Right
stated,
to
my
be.
lord. I'll go there, my lord. Your lordship kindly provided their details provided to me, my lord. Details of my lord account.
No.
What I am liability.
Mr.
My lord,
Mahto,
even my lord, your
Mr.
lordship kindly.
Mahto, please listen. these are dues you are bound to pay.
Exactly, my lord. I'm bound to
Question
pay. I
is-
never said that I'm not going to
Question
pay.
is whether this is the amount or is it something less?
My lord.
Now, you can't say that until and unless the notice is served to you, you'll never go to the authority and decide what is the correct amount to be paid.
My lord,
Then
here, my lord, prima
the
facie.
procedure prescribed under the act will follow. The consequences will follow.
Exactly, my lord. But now, my lord,
We-
from
we
the
give
notice
you a
only I
limit-
came to know, my lord.
We will give you a limited time to
My
approach
lord.
the authority.
My lord.
You approach the authority.
My lord, but your lordship kindly see prima facie, my lord. Your lordship, whatever the amount I have paid, I have annexed, my lord. That is not reflected in there, my lord.
That's right. So
I'll go there, my lord. Yes. But till that period, my lord, I will be protected, my lord. Otherwise, we'll take away my garden, my lord. Because your lordship knows, my lord, my
the
garden is, my
garden
lord.
can't be taken away like that. There is a
Yes, your
procedure
lordship,
for auction.
exactly.
No, my lord, they will immediately, my lord, they will put a my lord, they will put a my lord, receiver, my lord.
That is incorrect. They have after
No,
the
let them give
receiver. No,
let
your
them, my
lordship,
lord,
no.
giving undertaking that we are not
It's
going
under
to
the
receive.
income tax that lordship knows 15 days of notice, 30 days after sale proclamation. After sale, he has a right for 30 days to come and make the payment. So it's unfair to say that he doesn't have time. And lordship, the law is, he's open to challenge the provision by way of which we are not at the moment required to give him the record, the authorized
Is there an
certificate.
appellate forum?
Lordship,
Is there any appellate forum?
the authorized officer itself is the appeal forum because he's the person who reconciles all this. And lordship, it's very well to say today, I do not know. These amounts in lordship, I will show you on the scheme and the act. These are forms filled by them. They know better than anybody else in the business how much
Whatever,
they owe.
He says that certain discrepancies in the amount which has been calculated.
Lordship, what happened is he defaulted. So he left the garden. Then receiver got appointed. So there is a in an amount of 1.8 crores, there is an amount of 46,000 rupees. 46,000 rupees, which is we say so, period covered under receivership. Page 47.
46,000 only.
Yes, your lord. No, 85,000, sorry, 85,000. No? Lordship, he wants a stay of 1.8 crores due from 2,000 on the ground that at the maximum.
No, see.
That is their statement, my lord.
Even under the provisions of 15D.
Yes, your lord.
E,
Yes, your
he's
lord.
entitled, the recovery officer is entitled to
Correct.
look into his.
Authorized
state-
officer, not recovery, authorized officer. Yes, your lordship. That is my prayer. Please go to him.
Right,
The law provides,
So
and he
until-
need not come knocking at 226 door.
correct, but until the authorized officer decides to,
Lordship, which is why they're given 15 days time. Instead of wasting their time to come to this lordship, they should have gone to the authorized officer. They don't want to pay. They're buying time. It's pretty obvious to everybody. Then you can't complain that the law is unconstitutional because it doesn't give you an opportunity to be heard. The law is giving only opportunities.
yes, heard Mr. T.K. Mohantola, the senior counsel. So, MSG Goswami, led by Mr. R. Sharma. Appearing for respondents, all the respondents.
All the respondents.
Petitioner is the tea garden, aggrieved by the recovery notice issued by the demand notice issued by the recovery officer. Assam, what is that? Tea employees, Provident Fund.
Yes, T employees Provident Fund organization.
Dibrugarh zone. For recovery of an amount of rupees 1,87,93, 539.46. Stop. This recovery notice was the notice of demand was issued on the basis of a certificate issued by the authorized officer in terms of the provision of the some tea plantations Provident Fund and pension fund, deposit linked fund scheme act 2016. So, learned senior counsel for the petition strenuously urged that prior to the authorized officer arriving at this calculation, issuing a certificate of recovery of no opportunity of hearing was granted to the petition. He got stopped. He has already deposited an amount of rupees. How much did you deposit?
I have already deposited near about 50 lakhs, my lord. I have annexed 8, 9, and 10, my lord.
Lordship,
8,
not,
9, my lord.
In
Lordship, not over and above this. That all of that amount
We are recording his submission.
Okay, sorry,
He
apologies.
types, towards the payment of provision. So he submits that all these amounts are not reflected in the calculation amended. Petitioner had taken over the garden only the year 2022. Therefore, the entire demand raised from the year 2000 till 2022 cannot be settled on the writ petition. It has to be recovered from the authority who was in charge of the garden at the relevant point in time. So he submits that the details of the calculation may not be furnished by the authorized officer on recovery of, and therefore his notice of demand needs to be interfered till such time petition is rebut the demand raised on the MSD Hazarika on the other.
My lord, I have another submission, my lord, regarding my lord, receiver, earlier receiver, my lord, Genix, my lord, his period is also included to me, my lord.
We have
His
recorded-
due also, my lord.
we have recorded.
But I
The
didn't
Hazarika
know.
to the very
Everyone has
point
called.
important, the other end, spread with
But I know
that
it is good.
under the provisions of the Employment Act, under
আপনার pleading are wrong.
the certificate issued under section 15 capital B
Pero pleading are আপনি 85
and
lakh wrong
under
লিখেছেন।
15 capital E, there is the provision permitting the defaulter to approach the recovery, the authorized officer, and the authorized officer, upon being satisfied, may keep the demand in abeyance till such time the rectifications, if any, which are called for, may be made to the demand raised, and thereafter the amount can also be rectified and reduced. It is submitted that the petitioner was given 50 days time, however, he has not approached the authorized officer. It is submitted that in terms of the provisions of the Act, when there is a prescription under the Act, then the authorized officer who can grant time for payments can also rectify the demand rate. The petitioner is required to approach the authority. Learned counsel for the participant heard. Yes, Mr. Monroe, you want a notice or we close it, giving you liberty to approach?
Liberty refers till then, my lord, no course of action will be taken.
No, that till then can't be for eternity.
Yes, your lordship.
My lord, within, my lord, 15 days, I'll,
15 days ends in July 4th. Before
The-
July 4th.
from today.
The
What yes, Rajiv.
petition issued notice for me since the learned since the council has already represented that it's not
Why?
waived, furnished, petitioner is permitted to approach the authorized officer
Authorized officer.
uh, for clarification or rectification in terms of the claims made by the petitioner in respect of the use of the fund raised by the impute stated so and so. Upon the petitioner approaching the authority, the authorized officer, all relevant documents relating to the demand raised may be furnished to the petitioner and who will thereafter respond. Will thereafter file necessary papers and documents in support of his claim that the notice of demand raised is required to be rectified or reduced. So the petitioner will approach the authorized officer within 3 working days.
No, my lord, it will be within a week I left, not 3.
Within 1 week from today. So the authorized officer will thereafter look into the grievances and thereafter pass necessary orders if so advised. So let the matter be listed again on. Tell us when you can have it.
Document time.
31st July
Yes, Your Lordship. I think that's adequate time for the
31st
authorized
July.
officer to review.
till the next date fixed, the notice of demand raised dated so and so
Lordship,
shall
we are giving you an assurance, we can extend the time.
shall not be enforced without leave of the court. The interim order granted by this court will not preclude the authorized officer from redressing the grievances raised by the
My lord.
petitioner in terms of the court. Let it be listed again on 31st of July. The extra copies, if required, be furnished within 3 working days.
Let it be, my lord.
Lordship, one prayer. If you're granting stay, then Lordship, they can pay at least 30% the dues, undisputed.
Till 31st. Till 31st.
Okay. Okay.
Within, my lord, 10 days, I will oppose, my lord, because I have to take the
We have
certificate.
given you 7 days.
My lord,
You have to approach within 7 days.
my lord,
Oblige, Your Lordship.
deep lord.
May I please? The petitioner, my lord, also turn to page number 23. The allotment letter of the flat, my lord. It is dated 26 to 2016, my lord.
Page number,
Page number 23, my lord. This is the allotment of a flat to the petitioner, my lord. I will read only the first 3 conditions, my lord. The actual position of the flat will be handed over after completion of the electricity and water supply connection. The electricity consumed charges, water tax and municipal tax, etc. of the flat shall be borne by the allotee. And the 30,000 rupees have to be paid. And the flat was handed over to petitioner and he has occupied the flat without electricity connection, water supply connection. And he had repeatedly, in lordship, you start to page number 30, he had repeated that the representation before the board, the please give me the connection of the electricity connection. It was not, it was occupied without electricity connection. Then, my lord, the connection was not given to the flat. We'll turn to page number 35. Then a notice came, the so-called notice came from the board, my lord, that there has been an indulgence of theft by the petitioner. From a meter has been installed and there is indulgence of theft. The so-called notice was given. And the so-called notice was replied because the petitioner has not only took the possession of the flat, it is that particular flat is under lock and key. He is not residing it because there is no electricity. No agreement, it was not taken into, then subsequent so-called notice was given, my lord, and he has to approach the High Court, my lord, for not disposing of this representation. But we will turn to the page number 44. The order was passed by the High Court on 26/4/2024 to dispose of the representation. After that order, my lord, but you also take note that the allegation is that there is a theft under section 135 of the, there is a FIR has been lost, FIR has been lost under the Illicit Act, my lord. And lordship in page number 47, the now the recent letter has been sent to on 15/5/2024. There are 3 conditions have been fixed that unless you address these 3 conditions, that allotment of flat will be cancelled. 3 conditions, you are asked not to continue with such type of allegation activity in future. He wants me to admit that I have conducted the theft. Now the charge sheet has been filed against me. Now I am facing any charges. And you are asked to deposit the entire dues of the rent of the housing board within 15 days. You are also entitled to expedite the requirement of the new service connection shall also be borne by you. The connection you are taking in picture, it will be borne by you. Well, in the meantime, my lord, they are contemplating to cancel my allotment. I have given the representation on next page, my lord, page number 48, on 21/5/2024. That you are asking me to admit the theft without any trial, without neither charge till date, my lord. Charge has not been filed. And they contemplate to cancel my allotment.
yes,
Lordship. Lordship, the petitioner has not been residing in the flat in question, Lordship.
He was doing no
Anyway, in this matter, earlier also he approached in this Honorable High Court, Lordship. Already my learned friend has stated. Now, this matter I require to instruction, Lordship.
Well,
in the meantime, no course action should be taken.
Mr.
Here go, my Lordship.
We are going.
Lordship.
Setting up.
1 to 4, I am. I wish.
It is here, Mr. Cliff. By the petitioner is received by the, which order? Page 47.
Page 47, order dated 15/5/2024.
47, dated 15/5/2024. Whereby there is a move to cancel the, move to evict the petitioner from the flat allotted by, issued by the housing board. On the grounds and reasons mentioned therein. So, petitioner has filed a representation of dated 21/5, both which according to the representation has been let the respondent complete their instructions by necessary affidavits and account here to the effect of that is 2 weeks from today. The authorities may proceed with the hearing, but will not pass any order without leave of the court. Let the matter be listed after the determination. Petitioner will participate in the hearing if notices are issued.
Items 31 and 33 are same. None. What had happened in this case, there was a seizure was done on payment of full penalty, my lord, the goods were released. Now there is no dispute, they have acknowledged also. Now we filed an appeal now. Now the appeal is not being registered because the system is showing that we have to pay 100% duty. Now something is wrong with your system, what can we do?
100%?
We have paid actually to prefer an appeal. There is a requirement of payment of duty that we have paid. And on payment only the goods were released. Now they are not going ahead with their appeal on the plea that we have not deposited the penalty which was imposed. If your lordship to kindly come to page number 55, that's the assessment order. Page 55, just after that box. As per the above calculation, the penalty amount works out at 16,35,840. Now please come to my lord, page 62.
62.
Yes. Please come on top. Payment receipt. Then the figure is down below 16,35,840.
What was the demand?
16,35,840. Now please come to the release order at next page 63. Goods conveyance bearing so and so carrying good was inspected by me so and so on 23/9/23, and after inspection an order of detention was issued in form so and so on 5/10/23, and a notice in form so and so served on person in charge of the conveyance on 5/10/23. Owner or person in charge of the conveyance has come forward and made payment of tax and penalty as proposed, and the proceeding is drawn in this regard. In view of the above, the goods and conveyance are hereby released on 20/10/23 at 10:30 hour. Now, against this imposition of penalty, we have preferred an appeal. Now, as per the statutory provision, we are supposed to pay the penalty. That we have done. Now, what will happen? Please come to page 70.
Yes.
Now, this is what the system shows now. On top, appeal can be filed only after complete payment of taxes calculated in so and so. Please make the payment of the balance dues by and try again. I think something is wrong in the system.
This is the,
Now,
this
now
is the-
basically
this
you
is
have
what is-
preferred in a
This is what is reflected in the portal.
portal. Now, my lord, if your lordship will kindly come to page 71, this is our appeal in the form prescribed by the statute. Now, this appeal is not being registered because according to the portal, we have not paid. But this is our limited grievance, my lord. They should consider our appeal, nothing else.
Yes, Mr.
Lordship will post it immediately after vacation. I will have the inspection. Come up for the first time. Immediately on, let it be in a motion stage. I will have the inspection. Why it has not been considered?
I heard Mr. K. N. Chaudhary, the senior counsel assisted by Mr. S. K. Barua, Mr. D. Gogoi, appearing for the
33, okay.
respondents. For the
32 together.
respondent, petitioner is aggrieved by the
18
non-registration of
Yes.
deed, which was attempted to be filed, which was proposed to be filed
37 है
by the petitioner company against the, against which order?
Yes, my lord.
1310,
Yes. Appeal is, yes, 1310.
against the order dated 13/10/2023 passed by the Assistant Commissioner of State Tax, Guwahati, Assam, imposing amount
37.
of tax and penalty. So, according to the petitioner, according to the learned senior counsel, the amount of tax due, including penalty, has already been deposited, and the goods which were seized, goods belonging to the petitioner which were seized, have also been released. He has referred to the communication dated 2001/2023, which is the release order, which reflects that the person in charge of the conveyance has come forward and made the payment of tax and penalty as proposed, and the proceeding is drawn in this regard. And in that view of the matter, the goods and conveyances were released on 20/2023 at 10:30 hours in good condition. So it is submitted that since the payment has already been made, the goods have been released, the appeal which is sought to be filed by the petitioner is not accepted in the portal. And there is a message which is reflected in the portal, which to the effect that the appeal can be filed only after complete payment of taxes as calculated in table 15 within bracket A, and the payment is payment of the balance amount. Balance dues are to be made, and thereafter the process for registering the appeal will be proceeded. Stop. Learned senior counsel submits that when all the payments and dues have already been made and the goods have been received by the petitioner, the non-registration of the proposed appeal thought to be preferred by the petitioner company is causing a lot of hardship to the writ petition. Therefore, having no alternative, the petition is called para. Mr. Gogoi, standing out, submit that like and would apprise the court on the reopening date after the end. It is submit the matter is on what 15th,
No, it's not 15, my lord. Let it be on 19, my lord.
19 July. Accordingly, the matters will be listed on 19 July.
Right.
The advocate on record for the petitioner will furnish extra copies to the standing counsel to make it. Meanwhile, tendency of the writ petition will not be a bar
Bar,
for the
yeah.
respondents to proceed with the appeal.
My lord, may
Proposed-
kindly have item 37, same, only that dates are different. 37. okay.
it's a-
My lord, in item 37, the payment was made on 4/9, sorry, 6/9, and release order is 7.
Page number,
Page number 61 is the payment part.
page 61 in item.
61 is the payment receipt.
the receipt of
And
the
release order is, my lord, page 62.
release order and page.
Otherwise, same.
And what is the, where is the appeal?
Appeal is at page 70,
So date of the,
1/12/23.
so date of the impugn order is 4/9, I think.
Yes, 4/9, 4/9.
2023. Passed by the inspector. Yes.
And item 42, what 32, in this case, our grievance is, the goods were detained, we made the payment, and my lord, goods were released also, but no order, nothing has been issued. So now we are not in a position to take any step.
Item 32.
Two. No order under 129(3). So therefore, we could not prefer an appeal.
Goods have been released.
Goods have been released.
You have not made any payment because there's no
Everything, payment has been made.
payment made.
Goods released also. But no order has been passed. There is a requirement of passing an order under 129(3) within a period of 7 days. That they have not done.
Correct, it is reflected in some website or something? No.
Nothing. Since there is no order, we are not in a position to file an appeal also.
Where is the release order?
Yes. Release order is at page 51.
Insofar as item 32 is petitioner is aggrieved by the fact that accepting the payment taxes due. And the release of the goods by the concerned authority, the order of assessment required to be passed by the assessing officer under section 129(3) has not yet been issued, has not yet been passed. And as a consequence thereof, petitioner is unable to take any steps for filing necessary appeal before the statutory amendment. It's submitted that release order dated 10/11/2023 reflects that the goods, that the payment of tax and penalty has been made and the goods contained have been released in good condition. So, issue notice, returnable on it, going and list all these three matters together on 19th.
Different.
Before me, Lord, it is a high-handed and illegal action of the police, my Lord, Ding police. My Lord, I own a piece of land on which there's a commercial activity going on, the fishery and all. Now the police at the instance of respondent number 5 has been disturbing the peaceful possession. Now they call us to the police station with all the relevant papers. We go there. They say that these are all fake papers, so but you cannot go there. Now, this has been done at the instance of respondent number 5. Had my peaceful possession been disturbed by respondent number 5, I could have gone to civil court or vice versa. What business does the police have to stop me from my peaceful possession of my property? I've gone to the DGP, I've gone to the SP, I've gone to the Assam Human Rights Commission, but to no avail. I've been constrained to approach this honorable court.
No, what difficulties are you facing?
I've not been able to enter my property.
Occupied by whom?
There's no occupation, no other occupation. I am under occupation. I've occupied the land after buying the property.
Then?
But the police call me to the police station and tell me, don't go to your own land. Don't do fishing there.
No, but who's looking after the property now? Who's
nobody, my lord, nobody. It's a case of a civil nature. It's only a civil court can decide. I'm losing my business. I'm losing my money.
There is no order or any,
Nothing, my lord.
only phone calls.
My lord,
Only, you are called to the police station.
I'm being called to the police station with all the relevant documents of the land.
Uh,
I go there with the relevant documents. They said these are all fake documents, manufactured documents, and threaten me with dire consequences that you don't enter that land, piece of land. I will arrest you and will press you in the police station.
Yes, Mr. Hendik,
I have to take instruction, my lord, to buy.
only instruction there. Heard, Mr. R. Sharma, like, he counted it still by a- The petitioner is aggrieved that notwithstanding the representation filed to the competent authority, including the DGP, in respect of restrictions, in respect of threats purportedly issued by the local police,
The officer in charge of the Dhing police station.
by the officer in charge of the Dhing police station, that the petitioner should not enter a plot of land measuring 3 bighas, 3 quarters, 4 acres, covered by Patta number 102, tag number 110 of Magulmari Sub Moza in the district of Nogao, which was purchased by the petitioner and mutated in her name. It is submitted that there is a fishery on the said land, which is required to be looked after, and and the petitioner, on being prevented from entering on the land, is unable to do so and facing harassment and losses in respect of the investment that the paid the business carried out by the petitioner. So, having no alternative, the petitioner heard issue notice return on 2nd of August. Mr. J. Hendik accepts notice on behalf of respondent
1 to 4, lord.
4. Steps on respondent 5 by usual force and registered post ID. Let the respondents complete their instructions and file necessary affidavit if so advised as to why the petitioner is prevented from entering on a land claimed to be purchased by her by the respondent number 4 particularly. So, and I got petitioner suspect, the officer in charge, and respondent number 4 is acting at the behest of respondent number 5.
My lord, on respondent number 5, my lord, Dusty may be allowed. And we will
Dusty.
file a compliance affidavit.
Dusty is also permitted. Steps by Dusty is also permitted on respondent 5. An affidavit of compliance may also be filed. It is recorded on 2nd August.
Kamlaji.
Yes.
Wait, please, your lordship. But you basically, the jurisdiction exercised by the circle officer, Bojali Revenue Sector, page 47 is the vernacular. If I'm to read out that part, page 47, speak of it.
Yeah.
May I? মকা হয় নহয় ইয়াৰ দ্বাৰা আপোনালোকক জনোৱা হয় যে আবেদনকাৰী আবেদন মৰ্মে পূব মৌজাত অমুক চমুক গাঁৱৰ 96 নম্বৰ খিৰাজ মেধি পাত্ৰত 9 নম্বৰ ডাগৰ মাটি কিনা বেচা সন্দৰ্ভত অহা 12/6/2024 ইংৰাজী তাৰিখে দিনৰ 12 বজাত উপস্থিত থাকিবলৈ জনোৱা হ'ল। My lordship, so far as the circle officer is concerned, the recruitment is under the rules of 98 as also the service rules which follow in the revenue 115 amended. They exercise executive powers. It so happened that me and the private respondent, as the purchaser and the seller, entered into an agreement. Much of money was paid, something was left. There might have been hard bonds. I am not on that. And there might have been a complaint file or something. I don't have a copy of that. No, what basically would be, under the Limitation Act, the only thing which was left for them was either 54, 55, and 58, if I may just indicate, my lord. For specific performance of contract, 54, 55 for compensation, and 59 to cancel the instrument, either ways. So that jurisdiction is vested on a civil court, my lord. A circle officer, Mati Besakina, has no jurisdiction at all. I can understand in exercising past and executive mentioned in the CRPC at times, okay. Come within the domain of an agreement, a contract between two parties or competing to contract, and to adjudicate on that, that is beyond jurisdiction. So therefore, my prayer is, let the proceeding go. I'm not praying for a stay of the proceeding, but he may not come any finding, order, whatever, on the agreement of sale. Mati Vesakina, he has no jurisdiction, my lord. I have submitted myself to his jurisdiction to the extent that
Why are you, he's not even passed any order.
he has.
He may not pass it.
He would. If I start a train, it has to halt. He would. He cannot jump off the train, my lord. He has to pass an order. What I am on is that
No. He may not pass an order on the correctness of the agreement.
that's what has been noticed. That has been put on notice, my lord.
No,
He says that Mati Besakina.
that's all.
He has no jurisdiction of that, my lord. We are on a jurisdiction part of a circle officer, and circle officer come under two categories, my lord, circle officer and circle officer attached. Under the rules of 98 circle officer,
But this is about mutation, isn't it?
it's not about mediation.
Then?
Nothing at all.
Then?
The vendor apparently had an heartache, heartburn, went to the circle officer, filed some application, I do not know what. Now touching
You
upon
go and file an appeal before the DCE.
the DC appeal would come when he passes an order exercising jurisdiction. Usurpation of jurisdiction is a writ large, my lord. I am on that part.
This is
Let them have the instruction.
too sketchy to say that it was an usurpation of jurisdiction.
If I may rephrase my submissions, my lord.
Hmm.
On the reopening date, I'm not praying for stay of proceeding at all. On the reopening
Therefore,
date,
if you're not praying for a stay of the proceeding,
what I am on is that
participating
he
in the
may not,
proceeding.
the concerned jurisdictional circle officer may not touch upon the agreement.
Why should we say that?
That's what the notice is all about, my lord.
So if it is
With all
not-
humility.
if you're agreed by the notice, you challenge this notice. Why are you submitting that?
We had,
You are
we
submitting
have,
to
we have
jurisdiction.
challenged the notice on the count of jurisdiction.
We'll examine that. We are not inclined to pass an
but
order
if
how
he's-
the circle officer is to pass an order and what parameters. We are not
We have
inclined to
issued,
do that.
my lordship,
We can say once an order is passed, whether it is correct or incorrect, depending on the whatever material. that
put
is
it this way, my lord. That if I put it this way, if
But why should we preempt the circle officer?
put it this way, in case of any dispute concerning land, the CPC is to
He has
take
not
care.
passed an order.
I am on a different thing. May I just apprise your lordship on? I squarely follow what your lordship is saying. We have come too early.
For any authority to decide on the jurisdiction, it is the authority first who has to decide.
I
whether they
understand.
have the jurisdiction.
So what I'm
Raise these objections before the
Correct.
circle officer.
What I'm on, my lord, is that if a summons is issued by a court of competent jurisdiction, it would not have, under CPC, it would not talk about a criminal offense. Similarly, if a notice is issued by the circuit,
Inclined to accept this up.
let it come for motion on the reopening date, my lord.
All right.
Let it come for motion. In the meantime, they may get the instructions on that, my lord.
It's on 15.
In the meantime, let me get the,
What instruction?
they have to, my lord, on the point whether they're
What
adjudicating,
instruction?
whether they're adjudicating a sale, an agreement, my lord.
What are you asking? You are virtually asking the government officer to ask the circle officer what kind of orders he is going to pass.
Not enough. my lord.
What else?
I'm not on that. A notice has been issued saying that we are deciding your
Notice has been
agreement.
issued, you have two options, accept or challenge.
Challenged, my lord.
The challenge it, we'll accept it, see what notice is, whether this notice is competent to issue or not. we decide.
Absolutely.
What is this concept of what orders have not been passed? You raise these objections before the circle officer. Why are you not raising it? That you have no jurisdiction to do it.
The first day we had gone there with the council, nothing there, but we were told verbally that you
Not
kindly.
verbally. Why did you?
That's
say anything
that is where we are stuck, my lord.
why
that's
did
the
you say anything
catch-22.
verbally?
He has to speak it on the record.
No, you have been given a notice, you go and file an application. We are not here to give you advice.
No, I fully understand, my lord. But the point is, when executive authority is not exercising the jurisdiction in a manner so vested,
Where's the basis to say that
The
they are not authorized?
expressing, my lord, on the
They
notice
are
itself.
issuing you a notice. You can raise these objections that you have no jurisdictions. Stay put.
Very good. On the reopening, my lord.
with the liberty to raise that.
Mr.
objection.
Handy, get some instruction. What is it? What is it?
You may sure, my lord, that no order, nothing has been, my lord, order has been passed until date, my lord. If any order was in passed, my lord, he can approach in the.
You want the dismissal on reopening with dismissal?
I think-
50? Not today.
Not today.
It's
We'll come on
50.
that.
It's on 15.
They may get these thing, my lord, what it is all about.
They want to get, they'll get. We are not directing them to get.
All right.
Because we see no merit in your petition. You are virtually asking the court to lay down a parameter how the circle officer is to pass an order. Why should we do that? Why should we even enter into it?
I'll leave it on reopening.
May it please the Lordship. One of the petitioners herein are the tenants and the shopkeepers and business. They run their business through, my lord, trade licenses issued by the GMC. My lord, the Cooperative Committee, the lands are the government land, which are given for burial purpose and others. There is a Cooperative Committee formed there, my lord. The Cooperative Committee is not being financed by the government by any for running of the management. The Cooperative Committee,
Which Cooperative?
Guwahati Cooperative Committee in Adgaon. My lord, now, my lord, in the outskirts of the Cooperative Committee, they have located some shops, which, my lord, their rents are paid to the Cooperative Committee. My lord, once for replacement of the tenants, the Cooperative Committee issued notice that you have to vacate those land. My lord, we approach the civil court. There is a prima facie case. So,
No, these shops are established by who?
my lord, established by the Cooperative Committee. Respondent number 5. They have established those shops for management of the Cooperative Committee, so that, my lord, they run the management of the Cooperative Committee for paying the salary and others. Now, my lord, this Cooperative Committee, my lord, issued notice that you have to vacate the land. We approach the civil court. Civil court passed an injunction order that they should not be disturb the position of the shopkeepers. My lord, on that position, my lord, some of the persons, one of the member of the ex-committee, he approached the Guwahati High Court, suppressing fact that there was a civil suit. That PIL, there are some encroachers sitting over there running business. The division bench directed that you go to the public PLPC, Public Land Grievance Committee. They will hear the matter and decide everything. Then they will, after hearing both the sides on the issues raised, then they will pass necessary orders. And, my lord, the PLPC issued notice to us that you approach there. Well, we approached and we gave our documents and everything over there, my lord. During that time, my lord, there was a dispute in the Cooperative Committee. When there was a dispute in the Cooperative Committee, my lord, then there was again a suit between those parties, and there, the Cooperative Committee was not functioning. We approached the Deputy Commissioner where to pay the rent. The Deputy Commissioner said you paid the rent as per Assam Urban Rent Control Act in the court. That was the document I have annexed, my lord. That is at page 358. But the Deputy Commissioner said that you 358 last but one page, my lord.
Yes.
This is the Deputy Commissioner 2016. They said they have informed that your allegation has been submitted to the Office of Deputy Commissioner in connection with the legality of formation of Cooperative Committee. In the meantime, two Shamitis demanded claim as legal, and the regard a case was registered in the court. On Shamiti raised objection regarding the collection of rent from the shop house situated in the land of Cooperative. Under these circumstances, asked to pay rent through court under the provisions of the Urban Area Rent Control Act. This was the order issued. The vernacular is the next page.
Yes.
My lord, through this, my lord, we are paying rent in the court, my lord. Now, the PLPC committee, my lord, asks the Cooperative Committee, please say from which authority you have got the permission to ask them to set up shops over there. My lord, they say now there is a suit pending because we are not functioning, we are not being able to give you the reply because we are not the committee. Now, my lord, what happened, my lord? They have issued a notice under 18.2. My lord, 18.2, as has been held, my lord, your lordship, I will place a few judgments, one division bench and one full bench of this court. And yesterday, my lord, in WPC number 1057 of 22, the division bench had discussed Radha Kanu's case and have discussed this judgment, what I am placing before lordship, and said notice is a mandatory. And, my lord, in relying on 83, they have stated, my lord, I am placing this 83 judgment. 83 and my lord, one of 88. This is the full bench. In 83 judgment, my lord, your lordship will find regarding 18 to notice which has been served to us in paragraph 13, my lord.
No, what is your grievance here?
Reverse, my lord, they have issued a notice under 18.2 to vacate the land, vacate the shop.
What has the division bench here? Yes.
Division bench, no, division bench is a division bench judgment, my lord, here.
Oh,
Page,
yesterday.
paragraph 13, my lord.
Yesterday.
Yesterday said notice is a mandatory and everybody in a caste land has a legitimate expectation that that has to be decided by the civil court, and my lord, because the reference was only on the notice, previously judgments were there, the notice was not required. Yesterday it was said it is mandatory requirement because there is a legitimate expectation for everybody who are sitting over the government land. If they file an application, that has to be decided by a civil. That has to be decided and notice has to be given.
No, but he said it was Kabarstan land on which we talked.
No, this is the Kabarstan land. My lord, we are Kabarstan land. The Kabarstan committee has given us as a rent. The Kabarstan committee said that we are running these shops because we have to manage. The government does not pay us anything. Because we are paying the rent for the laborers, we are paying the management and everything. We are in the outskirts of the government, Kabarstan land. And there is a civil suit where is an injunction. Page 135, your lordship will find. There is an injunction, your lordship will find at page 135. Those things, page 135, my lord, second paragraph. In the light of the above discussion, I have the opinion that so far the tenanted shop room is concerned, the petitioner has been able to satisfy three golden principles of granting temporary injunction under such and such. Status quo order is hereby made absolute in respect of the possession of the suit premises. The opposite parties are restrained from disturbing the possession of the suit premises by the petitioner in any manner till disposal of the main suit. There is an injunction order. And my lord, in this 83 Supreme Court, my lord, yesterday even, my lord, the judgment, because I was the petitioner in that case, I was hearing the judgment. I have not been able to get because the judgment has not been online. My lord, I was hearing the judgment, it was delivered. My lord, the court has held, even in Radha Kanu paragraph 4, it has only described about the, regarding that, my lord, Toji is a penalty. And they have not discussed anything about 18. So that has been also clarified, my lord. And in 83 Supreme Court, my lord, 83 GLR, division bench at paragraph 13, my lord, have stated, if your lordship permits me, my lord, paragraph 13. Notice has been issued to us under 18.2. In a summary proceeding under Rule 18, the authority is not to adjudicate any complicated question of possessory right or title of the occupant. If it finds that there exists a semblance of claim of bona fide right, it should not proceed under Rule 18.2. While considering the bona fide claim of right, the authority should consider duration of the occupation of the land by the occupant, the nature of the property on which the encroachment is alleged to have been committed, whether the claim of the occupation or possession is mala fide or bona fide, where the property is occupied or possessed by a person, the authority competent to take action under 18.2 should not shut its eyes to the existing fact revealed from the record. If an occupant openly makes construction, his act might create a bona fide right, title or interest in the property. The duration of occupation is undoubtedly a relevant factor. When the occupation is open and for an appreciable length of time, when some right to occupy the favor of the occupant is detected, it requires an impartial adjudication. According to the established procedure of law, the length of possession, the nature and open act of possession, construction of the structure, dealing with the property as his own certainly created a bona fide right in his favor. Such cases should go to the civil court for adjudication, or the authority must take resort to other provisions of law to take resort to some other law. And this has been reiterated in my lord, in the other judgment that I am placing, my lord. That is a full bench judgment, my lord. 88 SCC, my lord, in paragraph 18, your lordship will find. Paragraph 18, my lord, the full bench has also, my lord, your lordship has got it. We finally refer to Kamalakanto such and such 83 to GLR, which was a case which dealt with 13 of the decision, paragraph 13 of the decision, that is summary proceeding. So we have discussed everything of civil right. The aforesaid decision of this court clearly shows that in two contingencies, the civil court jurisdiction would not be barred, despite which has been stated in section 154, or for what matter section 154 of the regulation. These two matters, when the question of title is raised, the order of revenue authority is illegal and without a jurisdiction. Malad, here, Malad, what my suggestion is this, Malad. Sorry, Malad, my prayer before your lordship is this. Malad, let them decide whether there is a bona fide right on my part, whether we are a tenant to that purpose, running over the business for last 30 years. Malad, suddenly by 18.2, without there being now the Kabarstan committee, been able to, at page, your lordship will find 155, my lord, where the Coverston committee in the PLPC meeting has said 215, your lordship. 215. The Coverston committee went before the PLPC committee and they have stated, my lord, the president of the working president of the earlier committee of the Coverston committee, by the aforesaid communication dated 16/4/24, informed that although they are elected committee, but the Honorable Civil Judge, Kamrup Metro in such and such, was pledged to grant an administrative injunction order restraining the functioning of president, working president, and also other office bearers of the committee. As such, they are not in a position to furnish a complete
Yes,
detailed
yes.
clarification on the
Let
queries
us,
sought
let
for.
us hear the respondent. Yes, what do you say?
Kindly come to page 151. This is the basis of the entire exercise. Page 151 of the writ petition. This is the order, my lord, passed by the division bench of this honorable court.
157 is relevant.
My lord, when he was submitting, I didn't utter a single word. I don't want any running commentary.
No, no, don't get irritated like that because councils are entitled to object and interject. It is a part of the practice. Accept it. Yes,
Lordship may kindly come to page 156.
yes,
It's a short order, my lord. May I read it, my lord?
yes. Read it.
At the learned counsel for the appearing parties, learned advocate general has placed on record the notification dated so and so issued by the Revenue and Disaster Management Department Settlement Branch, as per which public land protection sales (PLPC) have been notified for 3 different categories: rural areas, municipal areas, Guwahati municipal area. The sales have been empowered to redress the grievances related to encroachment over pasture land, catchment areas, ponds, rivers, lakes, public places, burial grounds, etc. We feel that with the constitution of these sales, the grievance of public at large pertaining to encroachment upon these categories of land would be redressed at the earliest, and the litigants would not be compelled to rush to the courts. We appreciate the efforts made by the state government in issuing the notification with the hope and trust that the sales will function efficiently. The petitioner who has raised grievance of encroachment upon Coverston land is relegated to approach the PLPC concerned for ventilating his grievances. Needless to say that the PLPC shall address the grievance of the petitioner in the light of the above notification, and shall hear the parties concerned before taking any action of dispossession, etc. The complaint may be filed by the petitioner along with copy of this order within 15 days from today, whereupon the PLPC, after hearing all the parties concerned and making the necessary inquiries, shall decide the same by a reasoned order within a period of 3 months from the date of receipt thereof. In case the petitioner is aggrieved of the reason so passed, the petitioner shall be at liberty to assail such order as per law. Lordship will kindly mark this, my lord. In case the petitioner is aggrieved by the reason so passed by the PLPC, he will be at liberty to assail such order. Thereafter, my lord, Lordship may kindly come to page 158, the next page. Pursuant to this order, my lord.
Where is the order of PLP?
Yes, I'm coming, my lord. Now, pursuant to this order, my lord, different notices were issued in the month of January. This is one of such notice. They have, my lord, annexed all the notices. My lord, what is the content of the notice? It is one of the, my lord, encroachers, that this is to inform you that the date of hearing for encroachers of government land covered by Dag number so and so Coverston of Sahar Guwahati under so and so has been fixed at 25/1/2024 at 12 p.m. On that day, the encroachers are hereby informed to present with sufficient documents of the scheduled land. The purport is, my lord, to give them a chance of hearing. So the conditions and parameters of natural justice have been complied with. Thereafter, my lord, after having issued such notice, my lord, the authorities, my lord, have passed an order that lordship will kindly find at page number 210. This is the minutes of the meeting. Page 200.
This is what PLPC.
PLPC. Kindly see, my lord. My lord, if lordship may allow me to read it, my lord, quickly, my lord. Minutes of the meeting held on 11/3. Lordship will kindly mark, my lord, that notices were issued in the month of January. This meeting is held in the month of March. Minutes of meeting held on 11/3 in the conference hall Office of the District Commissioner, members present, these are members, my lord. The meeting was presided by Srimati So-and-so, District Development Commissioner. The District Development Commissioner Revenue briefed the House about the topics of the meeting, discussion and decision of the meeting. The Circle Officer, Guwahati Revenue Circle, informed the House that in response to the resolutions taken in the PLPC meeting held on 11/1/2024, a field survey was conducted over the reserve land of Adgao Kabastan, and accordingly, office hearing were also conducted among the shopkeepers. Now, these are the persons who are before your lordship, my lord, who were running shops over the said reserve land of Adgao Kabastan, and petitions were also collected from the applicants. The Circle Officer, Guwahati Revenue Circle, has also apprised the House that at present, total of 74 numbers of shops are running over the said scheduled land reserved for Adgao Kabastan. As reported by Circle Officer, Guwahati Revenue Circle, no legal ownership or rights is there with the said shopkeepers to run their business in the aforesaid scheduled land reserved in favor of Adgao Kabastan. The Circle Officer, Guwahati Revenue Circle, also added that no permission has been accorded by any competent authority in favor of the said shopkeepers to run their business in the land reserved for the Adgao Kabastan, although they have trade licenses issued by the Guwahati Municipal Corporation to operate their businesses. In response to the above, Sri Sanjeev So-and-so, ACS, Additional District Commissioner Kamrup, has put his views on the matter and said that since government has reserved the land for Adgao Kabastan solely for burial purpose, so there is no any question of using the said land for commercial purpose. In this context, he suggested the PLPC to issue an official letter to the Kabastan Committee, thereby asking them to clarify as to whether the government or the revenue authority of the Kamrup Metropolitan District have accorded any permission in their favor to sublet the government reserved land reserved for Adgao Kabastan to the shopkeepers for their commercial use, other than the purpose for which it was reserved by the government. Now, thereafter, my lord, another meeting held. That lordship will find at page number 214, Annexure 10. So, a thorough exercise was carried out in pursuance of, my lord, the order passed by the division bench, my lord, in the PIL. And this is one of the minutes of meeting. Second minutes of meeting, lordship will find at page 214. That is dated, my lord, 22nd of May 2024. Earlier, it was, my lord, in the month of March. Then again, my lord, in the month of May. Page 240. If I may quickly read it, my lord. Minutes of PLPC meeting held on so-and-so. Members present. The meeting was presided by Sumit Chatwan, District Commissioner, Kamrup Metropolitan District. Decisions and discussion and decisions of the meeting. The District Commissioner, Kamrup Metropolitan District, made out the clarification forwarded by the committees of Guwahati.
Requires some hearing.
Yes, no, my lord, my submission is that, my lord, now in the PIL, my lord, Honorable Division Bench has passed an order directing, my lord, relegating the petition.
PLPC has held, but we would like to see on what basis, because you are making a statement. It's I think here that trade licenses issued by the GMC does not give you, certainly does not give you ownership right.
Yes.
But when an authority of the state has issued a license, and it said that you have issued it without verifying any document.
No, yes, that is one aspect of the matter. But, my lord, as a consequence of the decisions taken by the PLPC, these impugn notices came to be issued. These impugn notices, one of such notice, lordship will find, my lord. It starts, my lord, from, my lord, page. It starts, my lord, from page 220 onwards. And prior to issuance of that notice.
Let us go to the judgment. Where is the judgment delivered yesterday?
Yesterday, my lord, it has not been online.
Let it come.
It has been online. I have that.
If he has got it, my lord.
It has been online.
In today morning, then.
So let the matter be listed after reopening. Let me go to the judgment. Apprise the court. Meanwhile, don't proceed with the eviction.
Look, evictions, my lord, it is the outcome of the PIL, my lord. Now, they had been. No,
PIL did not decide on it. PIL then go to the PLPC.
The PLPC,
so PLPC has decided it.
PLPC decided.
Now, the judgment is with regard to the 18.
Yeah, 18 to.
Require some.
Absolutely correct. Yes, my lord. I got it. Now, here, my lord, These notices is not issued, my lord, unilaterally or, my lord, at one go. It is a culmination of an entire, my lord, process. Yes.
But considering that today is the last, otherwise you could have carried on next. We'll have it immediately after reopening.
On 15th month.
Lordship, may I am for as a caveat for response number 5.
Coverston committee.
That is the Coverston committee.
They are not functioning as on because of the mistake.
Lordship.
Yes. What do you think?
Lordship, actually that Lordship. What my learners of friend has submitted that already there are 2, 4, 3 title suits are going on, and that title suit Lordship, the honorable trial court has Lordship state granted injunction, temporary injunction. Lordship. Now the Lordship question is that if already the trial court has granted them injunction, temporary injunction, why Lordship the second injunction is necessary, stay of this proceeding is necessary?
We'll examine that.
No, that's true, Lordship, but thing is, one more thing is that Lordship, already Lordship, the TLPC has minutely gone through the records they have submitted before the TLPC. So after submitting,
We are examining this.
no, Lordship, nothing is that Lordship because of one after another case filing by this Lordship illegal occupant. This process of Lordship entire eviction is Lordship has been halted, Lordship. The thing is that because of Lordship increasing the event of Lordship burial, that now the campus of Lordship Guwahati Cooperative has been very reduced, Lordship. And one more thing is during COVID period, Lordship, around Lordship 300 Lordship corpse has been buried in the Cooperative. Now there is Lordship very short place of Lordship for burial. This is the main issue, Lordship. Otherwise, Lordship, all those persons, they have filed it one after another, they are filing these cases, Lordship. Only to Lordship continue their possession.
Naturally.
And one thing, Lordship, I'll also consider, if they are Lordship occupying that land since 30 years, 25 years.
How many petitioners are here?
My lord.
69. Yes. No document, Lordship will find.
66.
Starting from page, Lordship, that they have annexed their license.
Within the campus or outside?
The boundary of the campus, man.
They are
near my house,
front
man.
side, their boundary, Lordship, but then back side, Lordship, they are encroaching the land. This is the issue, Lordship. And Lordship, they are saying that they have been occupying the land since 35, 32 years. No documents at all has been produced, Lordship. They have already submitted the documents starting from page. Yes. Notice may issue at this stage, Lordship, but no stay, Lordship.
Mr. J. Kolita. For the caveat, in caveat numbers, caveat discard. Third, Mr. Rohit Chaudhary. Council. So third, Mr. Chaudhary appearing for.
I appear for respondent 1.
That's one. Then who else is there? A and D. 2, 3, and 4. Mr. Kolita, that's caveat. The petitioners are before the petitioners claim to be tenants running various shops and businesses under the Guwahati Cooperative Committee as 5. The respondent number 5. The petitioners claim to have executed proper agreements for tenancy with respondent number 5, and they were in occupation for several decades, running their shops and businesses. So the Cooperative Committee has now sought to evict the petitioner, and the process for eviction has been initiated, and the matter was considered by the PLPC.
Public Land Protection.
PLPC, and by their items of the meeting, it was held that the petitioners could not produce the relevant document showing the ownership of the land, and as per government records, the land is reserved for use of Cooperative purposes. Therefore, the department has proceeded to issue notices for eviction of the writ petition. So, and a counsel for the petitioner has referred to judgment of the court reported in dollar draft quoted in so submit that where the possession is bona fide and for substantial period of time. Eviction under section 18 of the revenue and Assam Land and Revenue Regulation will call for proper notice and procedure before such ejectment or eviction notices can be issued, as have been done in the case of the revenue. So, counsel to the bar also submit that the recent judgment of the different bench has been rendered
In WPC 1057/22.
in WPC 1057 of
22.
22, wherein the division bench has rendered a finding in respect of the question of issuance of notice
Under
and
18.
procedure to be followed in cases of evictions or ejectments ought to be initiated under Regulation 18 of the Assam Land Revenue Regulation Act. However, since the judgment was delivered yesterday, copies of the same judgment did not be delivered. Be that as it may, upon hearing the learned counsel, this court is of the view that considering the urgency expressed by the parties, matter be listed immediately after reopening on 15th of July. The matter, the respondents are permitted to complete their instructions and file necessary affidavit. And the question of till the next reasonable date, the eviction notices shall not be given effect to. Further continuation of the interim order granted will be reconsidered again on reopening date after hearing both the counsels, all the counsels.
My lord, your lordship will
It
fix
is
it on
15th.
15th. Can it be on 16th?
No, 15th.
Obliged.
Only one aspect of the matter. EMC is a necessary party.
DMC.
They have not arranged EMC because their whole repetition is premise founded on the plea that they are paying my lord license to the DMC, so they have a bona fide right, and they have my lord enclosed all the series of documents. But interestingly,
Let us take a call on 15th for the GMC.
Well, we'll file an application for impleading.
it will be necessary party.
My lord, we'll file an application.
Apparently,
You file an application.
My lord, we'll file. Obliged.
I am obliged.
It knows, my lord, earnings from the advocate, my lord, they are exempt from GST. That order.
There is a circular.
There is a circular.
In this case, what happened when the order was passed, the authority was not aware that the petition was an advocate. And his reply reached after part. Lordship may fixed after
He
reopening, I'll obtain instruction because Lordship difficulties.
authorities thought he was a member of a law firm.
No, Lordship, that is also not there. The thing was,
Law firms are also exempt. That your lordship will get it at page 22.
Lordship may fix after reopening, I'll obtain instruction because Lordship difficulty is this. Since the final order has been passed.
All the other cases in respect of all other advocates have been closed.
Yes, Lordship, this case was closed on the way because notice was issued. No final order was passed. Lordship may pass interim order and in the meantime, open
Heard
instruction.
Appearing for the petitioner assisted by Mr. J. Lotha, Mr. S. Gyal, appearing for the Department of Central Goods and Service Tax, appearing for all the respondents. The petitioner before this court is a practicing lawyer and advocate in this high court. He is aggrieved by, where is the notice?
First notice is dated page 13, my lord.
Final
It is
order.
dated 33/22.
He is aggrieved by the notice dated 3/003/2020.
And the demand notice. Is it
Issue.
demand is at page, my lord,
It is a final order. Lord.
25.
No, this is the order.
This is the order.
Demanding,
No.
This is the order
Final
Yes.
order.
then
Whereby-
page 25.
whereby service tax was demanded along with interest and penalty of the petition. So,
He filed a representation.
filed a application for rectification under section 74. Same came to be. What happened to the rectification?
That rectification, that order has not been passed.
Order
And
has yet been
suddenly, my lord, this recovery notice has been
It
issued
is
again.
submitted by the learned counsel that so far as applicant is concerned, they are outside the ambit of service act. Where is that notification?
Page 25. The demand.
No, not the demand.
That notification, that your lordship will get it at page 22. It starts from page 19. Page 22, that's an order issued in respect of notification. 26. 26 is there. Page 26.
You'll find it page 27 top.
Below, my lord. In respect of services provided or
Is
agreed
an
to
individual advocate
individual advocate or firm.
and therefore is excluded from the purview of service act. By the So this shows these are taxable services.
Yes. They have not taken into consideration this notification.
No, where is the exclusion? There is a
Exclusion page 27, my lord, your lordship.
no.
Page
You have
27 below.
please
last,
read below.
Below. my lord. Serial 5. In respect of services provided or agreed to be provided by individual advocate or firm. 100% exemption.
In respect of individual advocate, the services required to be provided by the individual advocate is nil, and the same is to be recovered from the person receiving service tax. Sorry, receiving the service. Under such circumstances, the impugned order dated Sweden issued by the Cooperative authority.
Dated 6/6/24.
Issued by the department itself. Therefore, by telling the department, Mr. HDR, the respondent submits that you wanted to place some notification.
No, lordship, I obtained instruction and public proceeding will be closed.
Submits that you'd like to complete his instruction, and he submits the matter still again on 17?
Lordship.
17 July, by which date you'll be able to apply for about the steps taken by the department. Let me listed on 17 July in order to facilitate Mr. Yal to obtain instructions expected furnished within period of 1 week from today and till the next returnable date, impugned order. Impugned order dated so and so shall remain stable until further order.
Lordship, I'm from H1 number 1 on
Miss
behalf of Esteban.
MS
Jedas.
J. Das, for Union of India.
Well, they may take into consideration this notification and pass appropriate order.
They will pass. Let us see on 17. They have already passed.
Yes,
In respect of so many.
Yes, lordship.
Why this kind of an order is passed?
No, lordship.
New officer, man.
New officer.
No, lordship, in notice.
He must have an angst against
No, not like
the,
No, nothing, lordship.
It's a mistake.
against somebody.
Apparently, bonafide mistake, because from name, he cannot identify whether he is an advocate or that is a difficult.
But he has
And
to look into
notice
the
itself
returns.
No, lordship.
So where is he?
In return also, lordship, it is not reflected whether it is.
This is from the payments made by the service
Yeah.
receiver.
Yes.
Yes.
Mr. Lotri, here, my lord, on the last managing body of the society, my lord, was found to be illegal, and accordingly, my lord, one-man committee was constituted on the report of inquiry officer. Your lordship will find the one-man committee at page 48, annexure 11.
Yes.
Yes, so my lord, this committee has formed by the my lord, Junior Joint Register of Cooperative Societies, my lord. And he has that one man, that officer on management has taken over the church and was functioning, my lord. Then, my lord, he was preparing the voter list also to hold the AGM and election. And he found the respondent number 5 is not the member of the society, my lord. So, my lord, his voter list, the name of respondent number 5 was not enlisted. In the meantime, the respondent number 5 has come to know this, and he has final representation before the Assistant Registrar of Societies, my lord. And now the Assistant Registrar of Societies on the said application has passed an order that is page 65, another 18.
Yes.
Yes, my lord. Your lordship will find so and so is seen that become a member of degree so and so, so and so. Under section so and so, the Assam Court Society members who were enrolled through co-option members are not deemed to have any voting rights. In addition to the above tenure of such membership is co-terminus with the tenure of the board of directors of the society. Then, my lord, next paragraph, page 66. Hence, the last one is the observation. In view of the above, your petition and claim of the membership would not be entertained against the share of so and so, and you may apply to management of the society for fresh membership subject to the provision of stated bylaws and so and so, so and so, so and so. Against this, my lord, the respondent number 5 filed an appeal before the Junior Joint Register of Cooperative Societies, which is not maintainable under section 111. He has filed an appeal, my lord, this one, that is 111, before the Junior Joint Register of Societies, which actually is to be filed before the Register of Cooperative Societies, my lord. Now, this Junior Joint Register has passed an order, my lord, in the appeal, restoring the committee which was dissolved by one-man committee, my lord, by appointing a one-man committee by himself, my lord. Your lordship by page 78. Order. His finding on the order. Page 78, my lord. In the light of the above and in the enterprise so and so, so and so, and so, justice I see so and so, so and so, in exercise of power delegated, this is not delegated power, my lord. This is an appeal. Appeal lies before the RCS, Register of Cooperative Society. Of the do hereby withdraw the order of appointment of one-man committee 1124. He has withdrawn that order. Then appoint management society resulting into restoration of BOD dated 28/8/22. He have restored that committee, my lord. So, my lord, we have come, my lord, against it, which is not maintainable, my lord. Anyone, if try to want to be a member of the cooperative society, their society, my lord, he has to file application before the managing board, my lord, before the board of directors.
Yes, what is it?
Let me obtain instruction, your lordship. Till
Hello.
notice may be issued. I'll obtain
What
instruction.
happens to this order?
This to be, my lord.
Till the notice, my lord, notice may be issued till then. I'll obtain instruction.
Because 111 is the appeal file before the register of societies.
You
Not
get
junior,
your
my lord.
instructions, we'll take it up at 2 p.m. Get your instructions.
Lordship.
Writ petition is found to be devoid of merit, same is dismissed. Interim orders, if any, stand vacated. Pending interlocutory applications, if any, stand dismissed. No order is to post. Records be returned back to the university.
Deeply obliged.
Yes.
Maybe. The lordship wanted to know whether the power, my lord, under 111 can be exercised by the General Register.
1 minute, 1 minute.
Right.
Yes.
Lord, in fact, 111, it says, my lord, there
an appeal would lie to the registrar.
No, no, now he's agreed by this order at page 69. is it?
Correct, my lord. That
Yes.
is passed by zonal registrar.
Hmm.
So therefore, the question is
Hmm.
whether the zonal registrar is without jurisdiction, my lord.
Hmm.
Whether he could have passed this order. Now, on this count, my lord, I would refer your lordships to, my lord, section 3.
Cooperative action.
এখন আছে নেকি? এখন বুঝে এখন এখন বুঝে এইখন লওক নতুন এখন পুৰণা কিতাপ এখন নহ'ব এইখন দি দিব
এই ভিতৰত আগত কোন পেলাই? Yeah.
3, my lord, 1 relates to the appointment of register for registration, supervision, assistance, etc. My lord, we are concerned with 2, subsection 2 of section 3. The state government may also appoint any other person or persons to assist the register and by general or special order in writing, delegate to any such person or persons all or any of the powers and responsibilities of the register under this act. So therefore, the delegation can be done by the state government by way of a notification or whatsoever. Now, here is a case, my lord, where section 87 is involved. Inquiry in respect of the cooperative society. Now, so far as 87 is concerned, my lord, there is a notification by the state government delegating the power of 87, my lord, to the zonal joint register. So in that view of the matter, the expression register finding place, my lord, in 111 has to be understood to be authority, my lord, on whom the power is, my lord, conferred. This is the notification of 23rd May, my lord, 2012. If your lordship sees, my lord, serial number 2, zonal joint register, power under 87, my lord, has been delegated to him.
Yes.
So therefore, my lord, this is a case where it cannot be said that the zonal joint registrar is, my lord, without jurisdiction in passing the order. So far as the correctness or otherwise, my lord, is concerned, I'll take the, my lord, the instruction, my lord, and if necessary, I'll file the affidavit, my lord.
Yes.
Yes, so for appeal is the quasi-judicial minor. Here to assist, not to assist, here RCS registrar of council will take decision minor. Decision minor in the appeal minor. In other cases, administrative matter, of course, minor power is delegated.
All right. Heard Mr. B. Sinha, appearing for the cooperation department, the petition is briefed by the order at page 69. The order stated 14th of June 2024. Whereby on a petition submitted by respondent number 5.
Five, minor.
The impugned order was passed and
Page 78. About it part.
by the impugned order withdrew the order dated 1/1/2024 appointing officer on management in the society, resulting in restoration of the beauty board of directors of the society constituted on 28/8/2022 and they were permitted to continue functioning to the rest of the for the rest of their term. So petitioner is aggrieved by this order in as much as that the respondent number 5 is not even a member.
Not even member, man. He's a co-op member. He was co-op member, man.
Of the society, and therefore at his representation the impugned order ought to have been passed. So Under such circumstances, it submits that the zonal registrar is not
Criminal
empowered-
joint register.
joint registrar is not empowered under the provisions of the Act to pass the impugned order. This was already passed on 14 June.
Yes,
Perhaps the BOD must have taken over.
yes, yes, correct.
No, but there is
This is, my lord, no interim order will pass. There will be chaos, my lord.
BOD, my lord, already once it was dissolved, my lord. There is also, I have
That's all
inquiry
right,
report
but
also.
that will amount to a final order.
Yes, my lord.
What is the status today?
There, subject to me, there is no committee, my lord.
So accordingly, issue notice returnable 4 weeks. Mr. Talukdar accept notice on behalf of
1, 2, 3, 4, my lord.
1, 2, 3, 4 steps on respondent 5 by usual course and registered post. Issue notice also on the prayer for interim returnable on July 29th. Any orders that may be passed by the BOD will be subject to such orders, subject to the outcome of the challenge made in the present.
Well,
Is accordingly on plan.
No, my lord.
Because granting an interim at this stage, you'll have to tell us what is the status here.
my lord, instead of 29, can it be some other day, my lord?
31st.
My lord, obliged.
Status, my lord, there is a dead member also in the inquiry report is there. 2 dead members are there. There also, I don't know how it is restored. Dead members will not come up, my lord.
We'll examine that.
Under 42, my lord, there is a power for co-option, my lord. The statutory power is there, my lord. Obliged, my lord.
Yes, Mr. Chopra, this is the matter which was listed on 25th, right?
This is GF now. This is the, item 6 is the first time.
What is this item?
Same matter, same, my lord,
Ah.
service tax matter.
Ah.
That is on the basis of the income tax report and without, on the presumption basis. And
No, no,
similar
you are
matter,
relying on what? You are relying on the
one judgment already passed by this honorable court.
26 form, form 826.
They are relying on.
So what is your submission?
My submission, my lord, this matter is already decided by this honorable court. In WPC number 1870, which I have annexed as case number 130, my lord. 129 is the annexer 13. Annexer 13, my lord.
Yes.
And the relevant parts from para 4, I can read 130, page 130. The petitioner takes a stand that in respect of contract works they had undertaken for which the service tax had been imposed, they are exempted under the law from payment of service tax in respect of some of such contractual work. In paragraph 4.5 of the informed demand notice, it is provided that upon perusal of the work order contract vis-a-vis Form 26 AS, it is not possible to establish against
No,
which
are you exempted under this mega exemption?
mega exemption.
You are exempted.
Mega exemption as well as there is provision of reverse charge mechanism, my lord. That is where the service tax is to be paid by the service recipient.
Where is the exemption notification?
Sir, my lord. That notification I have in next page 105, my lord.
105.
105. This is the notification where the specific contract or specific service, where the instead of the payment of the service by the service provider, service recipient is entitled.
Yes. Notification. Yes.
And in particular, my case, my lord,
You show us the notification. What is this service that you are offering?
this notification 30 of 2012, that is at page number 105, my lord.
What services are you offering?
Myself is giving the services of work contract service,
Work contract regarding what?
regarding the government services, my lord. That is Form 26, government agencies service.
So you show us from the notification, where are you exempted?
Yes, my lord. That is at item number, my lord. 9. In respect of service provided or agreed to be provided in service portion in execution of work contract service.
They are not exempted, you pay 50%.
That part we have paid, my lord.
Hmm.
And for that purpose, my lord, I have annexed the invoices also. Page number 124. What portion is taxable and what I have to pay. Page number 124, my lord. If the service, if the contract is original contract, service tax is to be payable only on the 40%. Otherwise, it is on the 70%. 50% by me, 50% by the service it is paid.
Yes. Now, what is the demand here? What is the order?
Order, my lord. Order is as page number 94, my lord.
Yes.
The demand is 1,52,35,948. It is on page number 104. And their calculation is, my lord, is page number 102. No RCM benefit, nothing. On the basis of 26 years, they are charging it. And similar matters are pending, my lord, in this portal.
Yes, Mr. Yeah.
So my first submission, what's it, page 94.
Yes.
There is a provision for appeal. And Lordship recently, this honorable court in WPC number 7378/2023 on 21/6/2024, after discussing all the judgments of the Honorable Supreme Court, come to conclusion that where there is an efficacious alternative remedies available. In any case, the SCC has to avail that. What's it now on merit? What's it come to page 100.
Yes.
Paragraph 15.
Yeah.
On perusal of the copy of audit report, it has been observed that CGST Audit Circle 2 has done audit of the notice for the period 2011 to March 2016, and Byte audit report dated so and so raised objection that the notice has not paid service tax of rupees 1,29,150 and works on works contract service, which was accepted by the noticee and paid the short paid amount of service tax along with the interest to government exchequer. No other details has been found mentioned in the said audit report. Thus, it cannot be assumed that the issue raised by the impugned order of the aforementioned audit report at the same. Further, the noticee has failed to submit any other document for the period April 2014 to March 2016, other than the above mentioned audit report of CGST audit team, to prove that the amount reflected in their Form 26 AS pertains to non-taxable service or the service tax liability was not upon them. Further, I observed that the noticee has filed a ST3 return for the period from April 2016 to September 2016 on 17/10/2016, which was later on received by them and revised by them, and revised ST return was filed on 11/1/2017 under Rule 7B of the Service Tax Rule 1994 as amended. The said original ST return had nil tax liability, whereas they have declared the paid service tax of rupees 6,61,000. Then paragraph 17, on scrutiny of ST3 return, for the financial year 2014-15 and 17-18 up to June 2017, it has been observed that the noticee was engaged in providing service under category of construction service, erection, commissioning and installation service, maintenance and repair service, and work contract service. The noticee have paid the applicable service tax on each category after claiming abatement. Deduction is taxable in terms of various notifications, numbers issued by the Government of India, and detail of the said abatement deduction not number were mentioned in the ST3 return filed for the said period. The detail of the taxable valuable service table by the there is mentioned below. And there are two tables. Next paragraph. It has been also been observed that the noticee has claimed abatement under notification number 3 of 2013 ST dated so and so in respect of construction service under notification number 24 2012 ST in respect of work contract in ST3 returns, which I hold that the noticee can avail abatement of taxable value in respect of both category of service under respective notification. Therefore, I hold that the notice is entitled to get abatement deduction of rupees 72,52,460 only on taxable value and during the period of.
Is the amount excluded from?
Yes, Lordship. That has been abated and that was accepted by the authorities. Lordship, let's come then, Lordship, page 20, paragraph 20, next page.
Yes.
It is evident from the detail mentioned in above table, the total service tax liability for the financial year 14-15 and to 17-18 was rupees 1,70,62,644. But the noticee has paid service tax of rupees 18,26,000 only through GAR7 challan, and there was short payment of service tax to of rupees 1,15,2,35 so and so. The noticee is thus failed to discharge their actual service tax liability during the said period. Thus, it is found that the noticee is liable to pay short service amounting to so and so. And after discussing and taking into exemption.
What about the judgment of the coordinator?
Lordship, it says that when there is an alternative effective remedy, they have to file appeal. Lordship, they have to file appeal under the provision of
page number 130.
Actually, in this case, court says that in paragraph page 131, the reading of clause 4.5 of the demand notice goes to show that the objection raised by the petitioner that for the contract work for which the service has been imposed, they are exempted from payment of service tax. This is the case; it's entirely different, Lordship. Here they are entitled to abatement that has been given to them. And after considering all the aspects, it is not that on the form 26 AS, entire liability imposed on them.
Yes. Why not an appeal?
That page number 131, may I take again, my lord? Para 5 and 6, my lord. A reading of clause 4.5 of the demand notice goes to show that the objection raised by the petitioner that for the contract work for which service tax has been imposed, they are exempted from payment of service tax, such tax, had not been conclusively determined by the authorities. The authorities, on the other hand, appears to have gone on presumption.
We'll have
I'm
we'll have to
taking
decide.
same thing here.
No, we'll have to see that order, whether it is
Yes, my lord.
decided.
That, my lord, may I take the so-called notice? Page number 86, my lord.
86.
86, my lord.
Yes. Yes.
Scrutiny of the form 26 AS collected from the income tax department, it is seen
You are
that the
reading from
TDS
which paragraph?
Paragraph 6, my lord.
Yes.
On scrutiny of the form 26 AS collected from the income tax department, it is seen that the TDS was deducted by the various service recipient, as the noticee did not submit any document regarding the service provided by him. There is reason to believe that the income amount on which the noticee paid the income tax was collected against the service provided. It is presumption.
No, how
Not
is it
conclusively determined
No,
that
but
yes, it is taxable under
how
the
will it
service
be
tax.
determined unless you submit the necessary documents?
My lord, there are provisions they can take, so my submission, my lord, whatever the judgment I have referred here, that is page number 1, that is the same, my lord. Yes, my lord.
Hard. notice Mr. SCKL and a standing hearing to the Department of GST. Steps noted on the application. Petitioner is aggrieved by the impugn order dated 27/3/2024, whereby demand of service tax along with interest and penalty has been levied. Being aggrieved, he has referred this petition. It is a submission that the entire service tax levied is on a presumption drawn from the traces
26
referred
years.
to under Form 26 AS issued by the Income Tax Department. He has also referred to a judgment of a coordinate bench rendered in page number 129, whereby this bench had held that imposition of service tax on the basis of information available from Form 26 AS would be imposition of service tax on mere presumption and the same. Being aggrieved, he has approached this court. Whereas Mr. KL raises the question of maintainability on the ground of alternative remedy. He submits that statutory remedy or appeal is available. Same has not been availed of. Being heard, learned counsel, let the matter be, let notice be issued, return about 4 weeks. Since the standing counsel appears, and accept notice on behalf of 2, 3, 4, 5. You are appearing for 1.
Yes, doctor.
Later. The respondents complete their instructions and file necessary affidavit. Matter be fixed. Notice also on the state prayer. Question of maintainability is left over. Matter be listed on 24th of July.
Lots.
Till then, my lord, no force.
We'll consider your prayer on 24th of July. You tell us why you have not gone for an appeal.
My lord, because I am on the exception case that this writ is live. Since this writ is live, since the order is without authority.
We
So
have to
that's why.
examine that.
That's why.
We have to examine that whether it is with or
Okay, my
without
lord.
authority.
For that period, my lord. In the other cases, my lord, there are a number of cases in the similar line, my lord. I must be taken with the same.
Can't be helped because
Same footing, my lord.
we are.
There are a number of cases. I can show the copy, my lord. Number of cases are there on
number
the
of
similar.
cases you should have pleaded it. You should
My
have
lord.
enclosed the
At
pleadings
least
here.
till returnable date, I may be protected.
We are not inclined to grant you an interim. We are not
No
inclined
question.
to grant you an interim. On what basis are you asking for an interim? Tell us.
My lord,
You have not explained why you have not gone in appeal. You go in appeal.
because my lord, this writ is
The claim it is not your case that the authority is not reposed with the jurisdiction to pass an order. Your case is that they have decided your case wrongly by including certain, relying on certain
No,
documents.
my lord, my case is that so-called notice is not maintainable because it is time bar too. It is time bar too, my lord. It is without authority. They are charging the tax
Therefore,
after July 17,
therefore go in
where no
appeal.
service tax was there.
Therefore, the normal course is to go in appeal. All these
That is
grounds you
normal
can
course,
take it
my
up.
lord. But since, my lord, till then that
Lordship,
protection may
with
be.
regard to submission of my friend, because there is a delay or time bar. This is not called the field because that demand is of the earlier year. And this honorable court under 170.
Notice must be issued within 30 months,
We
my
have
lord.
given you, if you want, we can give you an early date.
Early date may be given, my lord.
All right. And it's on 17.
Much obliged.
17.
My lord, say item 10 is also.
Item 10 also. Issue notice based on.
That was listed on earlier 24th, my lord. This item 10.
So there you submitted, I recollect the submission made by you.
My lord.
That service tax is levied even after 2017.
My lord.
But from the traces, it appears that these are dates only in respect of the transaction in terms of the payment.
terms of the payment after June 2017, my lord. Their basis is 26 years, which reflects all the
No,
transactions.
no. Kindly see that. Kindly see the page 36. Page 36 reflects the details of the transaction under 194C, that is TDS. It does not reflect to the transaction of your services.
Whatever the receipt I have taken.
You have kindly come to page 36.
My lord.
You see 31st of March
2018.
Your submission is that this is the date where service tax was not even invoked. This is not the date by which they have considered you have rendered services. Your services were rendered perhaps well prior to that.
It is not their case, my lord. They are taking that, they have taken as if only up to June 2017.
Show us.
In their so-called notice.
Show us. This is the date of receiving payments and deduction of TDS.
Yes.
So the payment is received on March 2018.
So your services may have been rendered earlier.
It is not in the so-called notice that all these services were rendered earlier, my lord.
So what?
Nowhere, nothing, no agreement like that in the so-called notice.
Show. Where is the show code?
Show code is at page number 65, my lord. May I read, my lord?
Yes.
Page 66 is the relevant.
Yes.
As the copy of Form 26 AS, so collected from the Income Tax Department, has been examined and found that during the financial year 17-18 up to June 2017, an amount of rupees this has been recovered. There
has been recorded in form so and so under section 194.
My lord, they are saying that I have recovered it, but I have recovered on March 2018.
No. This is the meaning of receipt of the payments and the deduction of taxes at source under 194C.
194C.
This is what is reflected. It does not reflect that you rendered services on that day.
So there is no averment?
No. Where averment is necessary for that? That's a mandate of law.
My lord, when service tax is up to June 17, they have to give the averment that service
They
is
don't have to give an averment. They are referring it here. It is apparently clear to anybody with elementary knowledge of financial records that this is a date for recording the transaction in Form 26 AS under section 194C. That is the day you have received payment to the receiver of your services and taxes have been deducted on that day.
That day.
Therefore, does it mean that you had rendered services on that day?
It is not their case that I have rendered the service earlier.
Your case?
My case that they have taken the entire amount of the 26 as recovered during the June.
Yes.
It is not recovered during the June.
No, we don't know. No, it's not about recovered. It's about when did you render your services. You show us date-wise that for each date, the services were rendered after 2017. July.
I will satisfy them.
Will you satisfy it? List on
same day.
18. Sorry, 17. We are not issuing notice here. You satisfy the court. Yes.
Find the additional exhibit, but we have also received some more papers which are very relevant from the hospital. Sign and submit this.
Bring it on record.
But actually, we received it only yesterday.
You bring it on record because what you're asking for.
Yes, my lord. But we have filed the additional exhibit.
No, you may have filed, but your documents don't reflect that he's suffering from mental illness.
It does.
It does. Show us.
That's what I'm trying to establish. That the diagnosis is usually written as
page 33. Page 33. Page
32 and
33. 33 doesn't say he's suffering from mental illness.
It says diagnosis F60.2. So this is the diagnostic manual that the mental illness is guided by. It's published by American Psychiatric Association. It's called the DSM-5. And in DSM-5, they have number coded all the diseases.
What is 60.2?
60.2 is that disease for anti-social personality disorder, they call it.
Does it qualify for
Yes, and
captive treatment?
it is. Because most of the murder cases are done by.
Oh, don't give omnibus examples. You give your example with regard to the facts of the case.
Facts of the case, because they are harmful to themselves and harmful to others.
No, there has to be a medical finding to that. Medical finding at page 33 is very clear. You see the status of discharge is improving.
That is true, but in its recurring diseases, and even here it is, not very clearly mentioned. Like I said,
And what is
diagnosis
the notification that you want?
that the court may be empowered to look into all this matter and call for records.
Yes, Mr. Gogoi, is there any notification?
Not that without instruction, empowering the courts to issue.
Whether notification is required under 2L, 2 of the Mental Health Care Act has been issued by the state, empowering the magistrate to function as such. Not there?
No, it's not there in the central lab, but I will have to take instruction.
This is the one you need to.
Please get your instructions here.
No.
Meanwhile, you can bring on record whatever else you want.
Yeah, the remaining documents that we have received
Yes.
yesterday.
Matter to be listed again on 29th of July. Meanwhile, the counsel appearing for the health department will apprise the court whether the state has brought out any notification under section 2 capital L within bracket Roman 2 the Mental Health Care Act 2012 empowering the functions of the magistrate, empowering the court to empowering a competent court to function as a magistrate as required under the provisions of the Act.
One copy may be served.
The petitioner, the respondent will apprise the court on the next tenable date in order to facilitate the completion of instructions. Sufficient copies of the writ petition be furnished to the standing counsel within a period of 1 week from today. Matter be listed on 29th. Meanwhile, the petitioner is also permitted to file the additional affidavit to bring on record any such additional documents as she desires.
My lord, I am appearing for respondent number 5.
Mr.
My name
Over,
may be shown. there.
respondent number 5, Mr. Horma for respondent 3.
Problem.
Yes.
Milord, I'll appear on. I will be appearing virtually, Milord. Milord, this petition is filed under against the order passed under GST, Milord. Mainly on the ground that the impugned order was passed without granting the personal hearing and also not considering the written submissions. And there is one more crucial point, Milord. The same issues which are agitated in the impugned show cause notice and order were already verified and concluded, and I agreed for some payments by the investigation agency in the year 2021 itself, Milord.
Why don't you go and appeal?
Milord, my submission is that, Milord, there are the exception to the alternate remedy, Milord. Here, first is that the orders were passed without granting the personal hearing, Milord, which is clear violation of the principles of natural justice. And second thing is, Milord, there is a section 6 of CGST Act, Milord, where it says that any subject matter, if the either of the central tax or state tax officer verifies and make any verification of the subject matter on this very same subject matter, the other corresponding or counter officer should not initiate any proceedings, Milord. In my case, the ITC reversal under Rule 42 is only the issue in this impugned order, Milord. The very same issue was verified by the DGGI Bangalore in the year 2021 for all the states of my registration. And he has concluded, my lord. And despite of me bringing this notice to the officer, the respondent did not consider and yes, proceed to confirm, my lord. The third thing is, my lord, why I cannot go for appeal is also, my lord. The order simply says my reply is not satisfactory and it is not supported by documents. And except this, there is nothing in the record why in the order to say why my reply is not acceptable or
Where
why
is
it
the
is not.
impugned order? Where is
Impugned
the
order
impugned
is
order?
1 second, my lord. Is it starts at page number 98, my lord.
Yes.
Next 8. And first 4 pages are summary of the order, my lord. The findings of the impugned order are page number 104, my lord. After noting down the repeating the my response, my lord, page number 105 is the findings, my lord. 104 and 105, my lord. 104 is the below portion. The bottom last line, my lord. Why they are confirming the demand? They say that reason cited by taxpayer was after writing that they say that reason the reply furnished by the taxpayer is not satisfactory and not supported by proper explanation as well as documentation, my lord. That's all it says, my lord. It doesn't say anything beyond this, my lord.
All right. You appear? Yeah.
For the central government, Lordship, basically they have challenged that extension notification. And Lordship has fixed the matter on 22nd.
That is also there in my petition, my lord.
Hereby Lordship, two high courts in the meantime held that this notification upheld the validity of the notification. When we come to page their basic prayer.
Extending the time limit.
Page 41.
Mr. Counsel, there are similar matters being urged,
Yes,
which are fixed on 22nd of July.
Yes, my lord.
So
That
we are
can be
keeping
tagged,
this-
my lord.
We are keeping this matter on 22nd of July, and we are issuing notices. Let the respondents complete their instructions and file necessary affidavit in the meantime.
My lord, there are two submissions, my lord. First submission is that, my lord, there are other grounds on the jurisdiction as well as natural justice violation, my lord. If at all that time limitation finally decide against me, the liberty may be given to me, my lord, to plead those other arguments, my lord,
No,
at the time of.
certainly you will get your opportunity to urge all the ground.
My lord, there is one more ground, my lord. There is already recovery made by the respondent, my lord, without allowing me to file or the petition or the appeal, my lord. 3 months are not even expired even today, my lord, but already they were recovered most of the demand, my lord. That has to be recreated, my lord. That recovery order that there was a balance in my input ledger, my lord, that was recovered without even waiting for the 3 months to
All right.
complete, my lord.
Heard, learned counsel for the petitioner. This petition is directed against the impugned order dated so and so. (29/4/2024) passed by the Deputy Commissioner of State Tax, Party C, Party Assam, whereby the input tax credit the petitioner was held to be claimed unauthorizedly and was directed to be reversed and was accordingly reversed. So, the further demands of the writ petitioner is that the assessment is otherwise time barred, but for the notification dated so and so, by which the limitation was extended. Notification number so and so, page 41. So, being agreed, the present writ petition is filed. There's one more ground. The impugned order has been passed without giving an opportunity of being heard. And notwithstanding the without granting an opportunity of being heard and furnishing of the relevant documents which are available with the petitioner in support of this case. Where Mr. S.C.K.L. represents the central GST. Mr. Odigari for
One, respondent one.
Respondent 1. Mr. Gogoi
2, 4, 5. 2 also.
4 and 5 appears for the state GST. Learned counsels for the respondent submit that they would like to complete their instructions in the meantime. Mr. KL, however, submits that similar matters are fixed on 22nd of July. Accordingly, let the matter be listed again on 22nd of July. Issue notice on the interim prayer, returnable on the same date. Respondents are at liberty to complete their instructions and file necessary affidavit. List on 22nd of July.
My small request on the interim prayer, my lord, there was already 70% of demand was already recovered, my lord.
We have issued a notice on interim prayer. We'll consider your prayer on 22nd.
Please.
Yes.
Under this petition is filed for impleadment, my lord, in this petition, we are the shareholders of the society, my lord.
Some interlocutory application is there. What is that interlocutory?
Yes, my lord, I am applicant.
Huh? Oh, this is the I. This I is for?
Or impleadment, of the respondents, my lord.
Impleadment. Who are you?
My lord, we are the shareholders of that society, my lord.
Yeah.
General member.
And who is the petitioner?
My lord, petitioner was the, my lord, also shareholder and member, but he is the president, my lord.
What is your objection here?
Lordship, first of all, the petitioner has filed his writ petition challenging the order of the respondent authorities, Lordship. My objection is that this writ petition is with regard to petitioner and the respondent authorities, Lordship. They have nothing to do.
What have you challenged?
Lordship, I have challenged the order dated 10/10/2023, Lordship.
Page number?
Page number 81, Lordship. Of the writ petition, Lordship.
Yes.
And Lordship, by order dated 17/11/2023, Lordship.
You are what in the society?
President, Lordship.
President.
I was the president, Lordship.
So in your place, the one man, what departmental officer is appointed?
Lordship. That has not been stated, Lordship.
So they are also members of the society.
Lordship, they are shareholders, but many of them are all defaulters also, Lordship.
Whatever. How is it that, how does it affect you?
Lordship, if they have something to say, Lordship, let them file a separate writ petition, Lordship. Because I am
Why do you want to be impleaded?
My lord, we want to be impleaded because, my lord, the writ petitioner filed by taking, my lord, and false belief, my lord, actually that meeting was not held. And impugn order passed itself, my lord, as there is no meeting held in the scheduled date as
All
per
right.
law.
List this, then we'll hear both the matters.
Lord.
List the IA along with the writ petition on
So, I humble submission, my lord.
On 18th July.
If we are not impleaded, I would not submit the WS, my lord. And one thing, my lord, due to interim order was passed, my lord. Our thing only that we have to run the society. The interim order passed by the allowed the petitioner society through one-man committee. Only stay was given regarding the annual general meeting. We are not on that the annual
We'll
general
hear
meeting.
you on 18th,
My lord.
on 18 July.
We are also wanted to perform the society, my lord, run the society. Otherwise, it caused heavy damage, my lord.
List on 18 July along with the IA. Attempt will be made to dispose of the IA along with the writ petition on the next 8 weeks.
Till the interim order.
Interim order passed earlier will continue till the next 8 weeks.
Interim.
MSM Dipora or the Cooperation Department.
Public.
You are appearing for respondent number 5.
My lord, we have no objection regarding the interim order. I have fetching problem. Interim order directed to run the society by one-man committee. But
We will hear you again
yes,
on
my lord.
18th.
My lord, yes. But one-man committee times and again appointed, but they are not corresponding with the one.
Whatever orders are there will pass on 18th. 18 July.
Oblige, your lordship.
May I please your lordship? Lordship, I have filed an IA petition, lordship, for interim protection of the Respondent Authority, lordship. Lordship, the main petition is, lordship, for illegal construction of a wide road, lordship, over the
Alright,
petition
you
of
should notice
state
here,
land.
heard learned counsel and the parties issue notice returnable on after 2 weeks. MSG Hazarika appears for
Respond number one, lordship.
respondent number 1 and Mr. DJ Talukdar represents respondent number 2, 2, 4, 2 and 4. And Mr. R. M. Das appears for respondent 3 and 5. The petitioner by the I has prayed for interim orders. Respondent opposite parties are permitted to complete their instructions and file objections if so advised in the meantime. Matter be listed on 29th July.
Your lordship, but here in this contempt application, I am approaching your lordship because my factory is closed because though there is a direction from the court, the culvert should be placed in my entrance and egress of my factory. They are not doing anything. Their names.
Lordship, here I am appearing for respondent number 1. I pray for some time.
From December, they should have.
This
placed
is
the
my first appearance, Lordship.
Because the order was that December, it was on his instruction, page 13, your lordship will find.
Let him file his objection, his response to see why the order has not been complied with.
Because my factory is closed since long, my lord.
Unless we hear it, we'll have to hear them.
Oh, within a short period, they should file it.
Yeah. Mr. B. Chaudhary, Mr. P. K. Roy Chaudhary appears for the petitioner. Mr. B. Chaudhary submits that he has received instructions to enter appearance on behalf of respondent 1. Office note dated 24/6 reflects that service on respondent 2 has been 80 card has been received back, which bears purported initials of the recipient, and therefore notice has been deemed to be served on respondent number 2. Who is respondent 2?
My lord, the project manager.
The project manager. Operating under whom?
My lord, near private parties, Brahmaputra Bridge, Pur North.
No, they are operating under
SP
whom?
Construction, SP Singh Construction Private Limited.
Huh?
SP Singh Construction Private Limited.
Operating under whom?
My lord, operating under
PWD.
My lord?
Under PWD.
My lord, my lord.
So you take steps to the executive engineer on respondent 2, fresh steps. Fresh steps are directed to be taken on respondent 2 through the office of the executive engineer, Brahmaputra Bridge, PWRD Construction Division, Potaki Lampari. Upon such notices being served on respondent 1, they on the office of the executive engineer, Brahmaputra Bridge, PWD Construction Division, the same shall be served on the respondent number 2 and the respondent number 1 and the executive engineer, Brahmaputra Bridge, PWD Construction Division, Potaki Lambari, will file affidavit of compliance to their effect. List the matter again on how much time you require.
Lordship, 3 weeks after vacation.
29th?
No.
29th July.
Okay.
Please, your lordship, that reassessment order, lordship, the other cases, lordship, on the basis of pleading they had admitted and no affidavit was filed, and lordship, we have also provided the thing. But lordship, this person is very, the Asian Paints Limited, They are very tax compliant. I was very surprised to see all their returns. Monthly returns have been filed before time. All the taxes have been paid before time. Only the annual returns have been filed belatedly.
I think it is covered.
Covered.
So far as, my lord, considering the similar order that they are placing, my lord, actually seems, my lord, in that case, my lord, it was submitted after the prescribed time limit. The chart is there. Now they have furnished a chart where it appears, my lord, it was submitted within time. So, my lord, to say that it is covered, my lord, that I don't think so. Don't think so.
Lordship, I'll show in 1 second that it is covered because
Lordship will see, my lord, page 81
monthly
of
are not-
WPC 6093 of 2022. Page 81 of one additional affidavit filed in 6093. Or Lordship may take up, my lord, here, page 4947, 2022. 4947.
Yes.
Page 77.
Yes.
Here, Lordship will see, my lord, the due date is, my lord, 21/5/2014.
They filed before due date.
Yes, 21 days is the, my lord, 21 days of the preceding month. It is to be filed, my lord. So it is within time. Now, Lordship will see the other case, my lord. The one, my lord, we have annexed in the additional affidavit. The chart therein, page 64.
Yes.
Here, Lordship will see the date is, say, my lord, in serial number 1, April 2009. It is to be submitted by May 21st. It was submitted sometime in June. So, my lord, the Honorable Court held that, my lord, for self-assessment prescribed under Section 35, there will have to be a assessment submitted within the prescribed time limit. Here in that particular case, it was not submitted, my lord. Despite that, no action was taken by the authorities. And for that reason, the Honorable Court said that, my lord, will not come under Section 40. Because there was no assessment at all. Under, my lord, from, say, from 29 to, my lord, Section 38. There will have to be some assessment in order to reopen it under Section 40. That was the gist of the entire case, my lord. And for that, I will have to read the entire judgment, my lord, of that particular other case.
So in this case, you are saying that since it was
within time, my lord, so 35 is already complied with, so we have the full authority to, my lord, open up go for reassessment under Section 40. That's my submission, my lord, in the present case, my lord. That's why I'm praying, my lord, Lordship will give me some
but
time.
where is the assessment?
My lord,
if it is filed within time,
yes,
according to you, and for a reassessment, there has to be an assessment. Some assessment order must have been passed.
that is impugn hearing, my lord. That is the impugn order they are challenging under 40. That's why I'm saying, Lordship will factually, some difference is there. I would like to file one affidavit to clarify everything, my lord. Because the amendment made in the writ petition have to be countered. And this has been submitted only yesterday.
Day before yesterday.
All right.
Lordship,
That's
only
why I'm
one thing,
saying.
Lordship, whatever they are saying, it is covered because they are saying that I am not filed delayed.
We'll examine it.
Yes,
We'll examine it.
It is delayed, Lordship. My annual returns have been filed in delay, and that is on record.
We'll have it immediately after reopening.
After 7 on 18, my lord, that Thursday.
18.
Yes, my lord, Thursday.
When will be on 18?
Subject to their convenience.
18.
18.
18.
These matters will be listed on 18th as the Standing Council submits that we like
Okay.
file necessary affidavit.
In the main repetition.
This matter may be kept part.
Yes,
The petitioner, the other end, counsel for the petitioner on the other end submits that this matter stands covered by the judgment and order rendered in WPC number 5858 of 2018, passed on 2/4/2024. The respondent counsel, however, disputes the submissions made. Accordingly, let the matter be listed on 18th of July. Since the matter was heard at some time, matter be treated to be partnered.
My lord, wait, please, your lordship, my lord. It is a matter of,
It has become infructuous.
no, my lord.
Why?
Because it is not becoming infructuous because of the fact that suppose I could not qualify this time. And if I have challenged the last portion of that appointment order and seeking a certiorari from this, I will court to expunge that condition given in my appointment order vis-a-vis the law laid down by the division bench.
Have you been selected or have you been permitted to appear or not pursuant to the orders passed?
Yes, I appeared.
You appeared.
Results have not yet been declared.
Results not declared.
Declared because
So-
of the pendency.
So
I suppose.
assuming results are declared, you are
I failed.
selected, you have no grievance.
I have grievance because tomorrow if there is another vacancy, my name will not be considered because of that particular sentence in the appointment order. Just like previous things.
Then until and unless the matter is decided,
Yes.
then even if you are appointed,
Yes.
you can't be.
I'll be subjecting to the outcome.
So-
No, my lord has given that observation in the first day itself. That even if I lord permits me, it will not confer any right upon me. But the thing is that I am told, my lord, the result is under seal cover. Result is not even been declared, it's not, seal cover is not open. Kindly see my prayers in the petition. That is at page 13. It starts from page 12. Bottom of the page. Until and unless that particular condition goes, I will not be considered in future.
No. That condition is no longer prevalent today in view of the division bench judgment.
That, my lord, that was not considered. That is why I have to come to before your lordship.
No, that is not considered by whom?
By the registry. That is why my name was not included in the first list.
My lord,
Then your lordship
my lord,
interferes.
he is not factually correct. My lord,
How can the registry disregard the division bench order?
That I do not know, my lord.
No.
Kindly see the list of the persons that were called for. Kindly see the
What is the stand, Mr. Bosho? What is it?
My lord, our stand is, my lord, what he has not placed, my lord, the notification dated 2nd March 2021, wherein it has been provided merit cum seniority.
No.
His all claim is regarding seniority. He said that he is the senior most. That is not correct, my lord. We have prepared the gradation list. He is not within the zone of consideration, my lord.
Gradation list is prepared from which post?
My lord, for both the posts, my lord. For the SJ plus in the assistant admin AO, my lord.
No. Tell me one thing. What is his post today?
He is working as court officer.
Is he confirmed in the post?
My lord, to that effect, my lord, he filed a representation and all these things are pending, my lord. And there are recommendations, my lord, to amend the rule also.
What is, you are now looking for promotion. You are now considering promotion. For promotion, is there a zone of consideration?
Yes, my lord.
What is that zone of consideration?
My
How many
lord,
persons to be called?
my lord.
How many posts?
One post, my lord. One post.
According to the
and he is not the not within the zone of
That's what
consideration.
we want to know. How have you calculated the zone of consideration?
My lord, for one post we are considering 5 applicants.
5
5
One
One is to 5.
One is to 5.
Now this 5 will come in terms of the gradation list.
My lord.
The gradation list from which post?
For both the posts, my lord,
Both the
for a administrative officer and my lord, SJ. In both the posts, he is not the senior. He doesn't come within the zone of consideration.
No, but he's what is a court officer.
Court officer. That's my different
You
cadre.
are in the rank. You are in the grade of what?
My lord,
Administrative
my lord,
Grade 2C. Class 2C.
Class 2C.
Yes.
Class 2C. Kindly come to the schedule then, my lord.
High Court rule.
High Court rules 1967, schedule 1 at page 665.
Yes.
Class 2C, my lord, 665. One administrative officer judicial. And he in clause 2C 3, court officer 2. My lord, kindly consider administrative officers, there are 25 posts. In the administrative officer and the court officer, if we consider, my lord, his seniority doesn't come.
Why?
My lord, that is Gedison list, as per Gedison list.
But as per what?
Gedison list.
Unless you want to say there is a combined gradation list.
Either the list has to be combined or there should be a different cadre-wise gradation. All these posts are under that class 2C and it's a feeder cadre for East and West.
Is there a combined gradation list?
My lord, it appears, my lord.
No, no, what do you mean it appears? Either it is there or not there.
My lord, I will file affidavit.
So you file affidavit, but in the meantime, because of your lack of instructions, there is an interim order operating.
My lord, your lordship has not stopped us from declaring the result. We are going to declare the result either today or tomorrow, my lord. Very soon, my lord. So, your lordship.
What is the interim order?
My lord.
That in interim order dated 11/6, my lord. Lordship may kindly peruse the paragraph 16 of that order.
Is permitted to participate.
Yes.
Then this will not confer any right.
My lord. And no whisper has been made, my lord, regarding the declaration of result.
Only thing lordship says.
There is no bar, my lord.
Only
we are going to declare the result, my lord.
That I know. Your lordship only said that if I got selected, then my appointment letter shall not be issued without the leave of this court. That is the.
They heard learned counsel for parties. Let the respondents complete their instructions and file affidavit. It is submitted by the standing counsel of the High Court, Mr. Bushra, that the petitioner was permitted to participate in the selection process, and interview was conducted. However, the results have not been declared as of date. You said seal cover for whom? For only him, for all?
No, for all men. It's not, no results has been.
It's not seal cover. Results are not declared.
Results are not.
My lord, that has not been stated, my lord.
Huh?
No, I'm instructed, my lord. The results has not been, even my.
My lord, we are going to declare the result.
That is what I'm saying.
That is what
it's not yet
declared.
It is submitted that the results as of date are not declared. Accordingly, it might be listed again on 31st of July, by which time the respondents may file their affidavit.
Problem.
Yes.
Your lordship has already noted the background of the case by an order dated 29/2/24.
Heard learned counsel for the party. This petition filed with the petitioner aggrieved by denial of the benefit of additional pension gratuity and the facility of the service of one telephone and a security assistant. Stop. This benefit was rejected. This claim of benefit was rejected by the respondent authorities, i.e. the impugned order dated 12th of April.
Yes,
12th of April. Correct. You check the order dated 29/2. Like that. After the order, the General Counsel for the petitioner submits that where the statute this is Right to Information Act, is it?
right. Unamended is below, my lord. There is an amendment in the year 19.
Yeah. According to the Right to Information Act, under the pre-amended provision of Section 14,
We kindly note that provided for last.
this is a pre-amendment of no, under Rule 13. This is under 13.
16.5.
16.5.
Yes.
Okay, 16.5 under terms and conditions prescribed under the Right to Information Act 2005. The terms and conditions for the State Chief Information Commissioner. The tenure and the terms and conditions under which the State Chief Information Commissioner. He is the State Information.
State information.
Where the State Information Commissioner and the State Chief Information Commissioner will hold offices are prescribed. So, under Section 16.5, prior to amendment, prior to its amendment in 2019, it was provided that the salaries and allowances payable to and the other terms and conditions and services of the State Information Commissioner shall be the same as that of the Chief Secretary of the State Government. It was provided, and it was provided also that at the time of appointment, if they were in the receipt of a pension in respect of any previous service of the government of India, the government of the state, the salary in respect of the service of the State Information Commissioner shall be reduced by the amount of that pension, including any portion of the pension which was commuted and pension equivalent of other forms of retirement benefits. Learned counsel for the petitioner submits that since the benefits were not granted, he had earlier approached this court by filing WPC number so and so, and by order dated so and so, the petitioner, the respondents were directed to redress the grievances of the petitioner and pass an approval. In consequence thereof, the respondent authority has have passed the impugned order. So, however, while doing so, they have referred to a judgment rendered, a judgment of a division bench rendered it by this Guwahati High Court within the Itanagar bench, which was rendered on different facts and circumstances and context, and accordingly rejected the claim of the writ petition. So, it is submitted that the respondent authority by the impugned order dated placed reliance on the judgment rendered by a division bench of this court in Eken Riba. Stop. In the same matter, the claim of the petitioners therein, where in respect of
Given a copy of the writ petition of that judgment,
where in
challenge the rules.
where the claim of the writ petitioners therein was to receive the proportional retirement benefits at no, what was the claim in the in Eken Riba? What was the claim?
Their writ petition, they have challenged the rule.
Hmm.
I'm just giving the copy, madam. They wanted the facilities of the Chief Information Commission.
They wanted the
Salaries of the Chief Information Commission.
where the claim of the petitioners therein was that they should also be granted the salary of the equivalent to that of the Chief Information Commission. On the facts and circumstances of the case, the state judgment division bench rejected the contention of the petition. Stop. The learned counsel for the petitioner has submits that
Kerala High Court judgment is that one taking medical benefit as that of the Chief Secretary was given. Your Lordship got it.
one minute submits that relying on the judgment of the division bench, the impugned the respondent authorities have held that in order to be entitled for pension under the CCS pension rules 1972, more particularly Rule 49, there is also a corresponding requirement for a minimum qualifying service of the person concerned to have served, and the minimum qualifying service was 10 years. But as under the provisions of RTI Act 2005 relating to appointment of State Information Commissioner, term of appointment of the period was found to be 5 years. And the minimum qualifying period of 10 years of service having not been satisfied, the case of the petitioner was stopped. Learned counsel for the petitioner has strongly submitted that the facts and circumstances involved in the judgment rendered by division bench of this court in Eken Riba is entirely different from the facts and circumstances of the present case. He further submits that a similar issue came up before the Kerala High Court, and by judgment and order dated 11/4/2023, Kerala High Court allowed a similar claim of a petitioner therein. So he has pressed into service the judgment of the Kerala High Court in this context to submit that where the provisions of the RTI Act specifically grants the benefits sought for by the petitioner, the same cannot be taken away by the respondent authorities without there being an amendment of the relevant sections. Stop. The respondents have contested the matter of filing their affidavits and have held that since a division bench of this court has already rendered a view that to avail the benefit, to avail the claim of the benefit as claimed by the writ petitioner, the requirement of 10 years of minimum service is necessary, and since the petitioner does not possess the same, it was rightly rejected by the department, and therefore there is no infirmity in the impute order issued by the competent authority. Learned counsel for the parties have been heard, meetings on record have been carefully produced. Before proceeding further to decide controversy before this court, it is necessary to refer to the relevant provisions of the Act. Section 16 of the Right to Information Act is relevant, more particularly Section 16(5). Relevant to the Section 16 is expected. Section 16(5), prior to its amendment in 2019, is expected below. So, the petitioner was appointed as the State Information Commissioner
Page 36.
by order dated 31/7/2015, and in the state appointment order, it was specified clearly that his term of office and conditions of service will be regulated as per the provisions of Section 16 RTI Act 2005. So, under such circumstances, it is relevant to refer to the provisions of Section 16(5) prior to its amendment in 2019, as the same is relevant for the purposes of this particular case. Under Section 16(5), prior to its amendment in 2019, it is clearly provided that the State Information Commissioner shall be the salaries and allowances payable to the State Information Commissioner shall be the same as that of the Chief Secretary of State Government. So, in this context, it is necessary to refer to the judgment passed by the coordinate bench in a petition filed by the writ petitioner in the earlier round of litigation. The writ petitioner being agreed, a writ petitioner and another similarly situated person had approached this court by filing WPC number 4497 of 2021, which came to be disposed of by coordinate bench on 16/11/2022. This writ petition was prepared by the petitioner and another. Was on the question of, was on the similar issue, was on the exact question of whether the state information officer, commissioner, is be entitled to the retirement benefits, including pensionary benefits and other service benefits, in terms of the condition of the service equivalent to that of the chief secretary of the state. The order dated so and so, passed in WPC so and so, is extracted below. A careful perusal of the said order reflects that at para 7, the coordinate bench had returned a finding that the stand of the respondents therein, that the two writ petitioners, having neither served as chief secretaries nor in the rank equivalent to chief secretary, would not be entitled to the benefits of salaries or allowances or other benefits of that of the chief secretary, was turned down and held to be unacceptable. In view of the legal fiction under section 16(5) of the RTI Act, that they would be statutorily entitled, as provided for, to the terms and conditions and salaries and allowances of that of the chief secretary of the state. So, in view, in the opinion of this court, there is a categorical finding by the coordinate bench in the earlier round of litigation that in view of the legal fiction created under section 16(5) of the RTI Act, the petitioners will be entitled to the benefits as prescribed under the statute. So, nevertheless, the coordinate bench disposed of the writ petition, directing the authorities to pass a reasoned order within a period of 2 months. And a consequence thereof, the impugned order dated so and so was issued by the respondent authority, rejecting the claims by placing reliance on the judgment of Ekinreba. So, the judgment rendered by Ekinreba does not reveal clearly that the petitioners therein were similarly placed like that of the present petitioner. So, the present petitioner is a member of a civil service, union civil service, and he retired as the OSD of which department did he retire?
Auditing.
OSD of the Department of Accountant General, Office of the Accountant General.
These are the accountant, principal accountant.
Principal Accountant General. So, under such circumstances, the petitioner, being a member of the civil service, union civil service, is entitled to be covered under the CCS pension rules 1972. Stop. Under Rule 49, CCS pension, it is clearly in the of the CCS pension rule, it is clearly provided that a member of the union civil service in case of a government servant retiring in accordance with the provisions of the rules, the government servant would be entitled to pension as provided for under the said rules. Under Rule 3(1) within bracket I. Government means, government is defined as central government. So, under Rule 13, Rule 13 provides for qualifying service of the government service. So, from a perusal of the CCS pension rules 1972, from a perusal of the CCS pension rules, it is clear, 1970, it is clear that a member of a service who superannuated from the services in terms of the rules would be entitled to the pension as provided in Section Rule 49. So, there is no dispute that the present petitioner is drawing his pension after superannuating from his country under the union. So, under such circumstances, the rider of qualifying service of 10 years has been held to be necessary to avail the benefit of salary and allowances equivalent to that of the chief secretary by the respondent authority is completely missing. So, in the context of judgment rendered in Vicky regard, there is no finding that the appellants like the petitioners therein were also government service or central government service. Under such circumstances, perhaps the division bench of the view that in order to avail the benefit, qualifying service of 10 years was mandated. So, in the fact of the present case, there is no dispute that the petitioner is a member of the central services, and having been drawing the pension under the CPS pension, satisfies the parameters necessary for qualifying service. So, however, save and except the finding of the judgment rendered in Eviction, the respondents have not been able to submit, not been able to place any material. That's why the benefits conferred under Section 65, as it tends to the right, 5, should not be conferred on persons found to be otherwise eligible. So, that apart, the coordinate bench by judgment and order the earlier round of litigation has returned a finding that by virtue of the legal fiction created under Section 65, the petitioner will be entitled to benefit of pension and other allowance, salary and allowance of that of chief secretary. Therefore, from all the discussions made above, the judgment referred by the counsel for the petitioner rendered by the Kerala High Court also returns a clear finding that since there is a mandate of the section under RTI Act that a member of that a state information commissioner would be entitled to the benefit, salary and allowance of the secretary of the state. The same
Medical
would
benefit.
be- Sorry?
Medical benefit as that of the chief secretary.
Medical benefit.
Other benefit.
Other benefit. Same cannot be denied as the mandate of the statute. Whereas, in the opinion of this court, the view adopted by Kerala High Court correctly reflects the position of the statute. In addition, there, in view of the finding of the coordinate bench rendered in the that by virtue of the legal created in section 65 of the Act, the entitled the benefits as mandated under section comma. This court is of the view that the impugned order issued by the respondent denying the benefit as conferred under section 15 cannot be accepted. This court of the further opinion that the coordinate bench by the earlier by the judgment and order dated rendered in WP had returned a definite finding that the petitioner would be entitled to the benefits conferred under the section 65 of the RTI Act of 2005. So, however, instead of interfering the order in a direction or directing the or passing an order directing the benefits to be conferred on the matter was remanded to the authorities to pass and examine the matter and pass speaking. However, the finding returned by the coordinate bench has attained final the state has not preferred an appeal against the finding arrived by the court. Stop. Under such circumstances, this court will be considered view that the petitioner will be entitled to the benefits for salary and allowances as conferred under section 16(5) as it stood prior to the amendment in 2019. Stop. The respondents are directed to both release and confer benefits receivable by the petitioner in terms of this order and read with section 65 prior to the amendment of the 19. So, the entire exercise will be completed within a period of 60 days, 30 days. 30 days.
Ready with the file. They are ready with the file. They have given this copy of. Only what I wanted to point out at page
Do you want us to
55.
record this? That last instruction you have given us?
That is not admission. In fact, I have read it again.
No,
Anyway,
only
my lord,
page 55.
only one thing, my lord. We did not prefer appeal because pursuant to that direction, we have taken up the matter and impugned order was the outcome of it.
No, that's what we said. There is a finding by the coordinate bench.
Right.
That has not been appealed or reviewed again. So it is binding.
No, by that coordinate bench, my right directed the respondent to pass a reasoned order. So we have passed a reasoned.
No. If you see
the finding of that was not.
If you see para 6, I think, of the judgment, para 7, 63.
Petitioner has retired on 31/12/19. All the benefit will be on 1/1/1/20.
31/12/2019. He is retired as what?
As the Chief Information Commissioner.
As chief,
State,
state information.
State information. And the Chief Information Commissioner state, he has been given that additional pension that I have shown. So that benefit and the beyond benefit has to be given. Beyond they give some 9,000 rupees per month, 9,500. The benefit has to be.
Para 7, if you see,
Right.
there is a finding that the stand of the government is unacceptable in law. The stand of the government that
Yes.
did not serve as chief secretary
Yeah.
or in the rank of equivalency has been unacceptable in view of the legal picture. This is a finding. This has not been altered.
We
It
have
has
not
not been
checked.
altered.
We have- yeah.
So it is binding. So, it is since it is submitted that the petitioner retired as State Information Commissioner with effect from
From
1st of
31/12, he retired on 31/12.
retired on 31/12
19.
2019.
And he-
Therefore, he would be entitled to the benefits and allowances under section 16(5) with effect from 1/1/2020. 20. 2020. So,
And the Chief Secretary was
it
getting
is
the
also
benefit of.
submitted that the State Chief Information Commissioner has already been released the benefits as payable under
16/5, including
under
additional
16(5), including additional pension.
pension.
Stop. Accordingly, the benefits that will accrue to the writ petitioner in view of this order, namely, what are the benefits?
Benefit, my lord, that your lordship will get it at page 51. Telephone and security assistant is one. Additional pension is another. Then additional DCRG, page 51. This was the
Page
information.
51 would be
Additional pension, additional DCRG,
additional pension, additional DCRG,
RG, then the telephone and security assistant,
telephone and security assistant.
as has been provided to the Chief Secretary.
That's all.
That's all.
Should be conferred on the petitioner in terms of within a period of 30 days as directed above. Writ petition stands allowed and disposed of in terms of
Declared.